Podium. Good evening. This is the Board of Appeal, Malden Board of Appeal hearing for December 19th, 2019. We have minutes from last month. Did everyone get a chance to review those? And any comments, questions, concerns, or a motion to accept? Okay, and a second? All those in favor? Okay. Minutes from last month, November 20th. We have 5 petitions this evening. I'd like to start with one that was held over from last month, which is the sign on the plaza down at Broadway. So this is the petition 19-014 by Ed Spinney of Sign Art, Inc. on behalf of WS Development for a variance of Section 3.35.9.3.2.1, Chapter 3 of the Revised Ordinances of 1991, as amended by the City of Malden. Sign design control ordinances, namely the dimensional controls for sign size as per plans SGER 031199-2019. This is at the property known as 39 Broadway, which is also known by the Assessor's Parcel ID of Map 125, Block 481, Parcel 103. Again, this was continued from last month, and it's Mr. Spinney, correct?
Yes, it is.
Okay. Did we advertise?
Yes, and you have your cut sheets.
Okay. So if you just give a little summary to the board members what it is you were looking to do and why you must come in front of us, why it's violating.
Good to see everybody. Thank you. We are looking for a larger sign than normally accepted in the city because we are set back so far. You should see some drawings that will show how far back we are set and actually show you the other signs in the plaza like Dollar Tree and so forth, how, from the distance of the street, we took that photo. So we're requesting slightly smaller than allowed by the city due to visibility, and we would just, answer any questions and hope that you understand the reason why we need to be a little bigger than the average sign in Malden.
Is it singular sign that we're talking about?
This is one sign. It's a new gym that's taking the entire woodworking area that was in the corner of the plaza at Stewart's Plaza. Now I'm showing my age, Stewart's Plaza.
How about Raymond's?
Yes, I remember that too. I grew up on Taylor Street right next to it, so I remember when it was Gil Weiner's, which I probably got you beat on that one. So just for the visibility's sake, to help the client be successful, he's taking quite a few square feet of that whole corner of the building to put in a new gym. It's a specialty gym, unusual, supposedly different than everybody else's, but he's spending a lot of money and effort into doing a nice build out there, and I think it will be a good addition for Malden. So we just want to make sure that it's big enough to be seen without being obtrusive. So, our opinion is that it's not over. If you look at the Dollar Tree sign that's in the photo and so forth, we're not that much bigger in a sense than they are. So,
could you tell us what the size is and how that varies from the why it violates the zoning?
We're at 68 square feet. I don't have it in my head, but 50 square feet is allowable, I believe, in that zone now, because they just changed the zones. I knew them by heart. But we're definitely over 10 or 15 square feet of what should be.
And again, allowed. It's one sign.
And it's one sign alone, yes.
Okay, and do you think your proposed sign is consistent with the abutters and the neighbors, the liquor store and the Dollar Tree?
Yeah, based on the photo, and I showed you a photo of the entire plaza. I took it from the main road, so you can kind of see that Dollar Tree is almost identically the same size. I think that we're not obtrusive and we're not oversized in comparison to others. And I think possibly other people have come before you to get changes of sizes for that plaza. I'm not sure about that.
Okay.
I mean, if you look at the Asian market, that's bigger than what we're asking for as well, too. And then you can see that in the side of the photo.
Yes.
And they're much closer to the road, actually.
Yep. And you could argue it's multiple signs.
So we've been in town for 42 years, so I don't want to do ridiculously large, stupid-looking things, and we're trying to be reasonable for both the city and the client. And he has so much frontage, we actually could make a bigger sign, but it just doesn't look right on the front of the building.
Okay. Catherine?
I'm looking at your proposed channel lettering on front wall, kind of taken back. It looks like you photoshopped in maybe a logo.
I did not Photoshop. That's an actual photo from the road. I Photoshopped my sign in, yes.
That's right.
To scale, yes.
So is this logo above the Metroflex
The logo
gym?
above has been removed because they changed the logo, so we removed the logo. So
Okay.
it's just the word Metroflex Gym Boston.
Okay.
So the one you have is been changed because it was
So
way
it's without
too,
the logo,
way too big at that point.
like the rest of
yes.
the drawings. Okay.
So that brings our square footage down to 68 square feet.
Great. That was my question. Thank you.
Great.
Okay. Adam? Is this thing jammed? I feel like it's caught.
Are the other signs that are in that plaza, the Dollar Tree and all that, are they in compliance right now with the sign control ordinance?
Oh, with today's ordinance, I don't know. I truly don't know. The ordinances have been changed recently in the past, 2 years, I think. So I believe the sizes were downsized with that new ordinance. I would have to believe that they probably were within ordinance, but maybe not. Maybe they came before you guys, 10 years ago or 5 years ago when they put them in.
And is there a sign out front of all the businesses?
There is one pylon sign that exists that's
Yeah.
already permitted, and it has like 6 or 8 spaces on it for clients.
Is that available for the gym? Could they have their?
The gym is going to have a small section on that as well, but that's been discussed with the building, and by right, that's a non-issue because it's existing.
Adam, you have the picture that
Yeah.
shows the other folks that are in there for comparison purposes on size. Okay.
And it's just a very large store. He's taking a lot of square feet, so, we're not trying to make them obtrusive and huge, but we're trying to make them at least visible from the road so that when people do see the pole sign, if they do, it's very high up, his panel actually, so you may or may not see it. If you turn your head, you can actually see the name, and if you were looking for it, you'd go, oh, there it is, and you'd get there.
I think I heard there was about 38,000 square feet that they are going to occupy.
I just wanted to make a comment. It seems like it's pretty comparable to a number of signs, and I think it's almost a safety-related issue. Given that it's such a distance from the street, it's sort of a different way of seeing signage. You want to be able to see it as you're driving before you get into the parking lot so that you know where you're going. So I would say it's definitely a unique location in terms of the entry to the parking lot where someone would start to look for a sign.
Agreed. He's in the corner over there, and it's tough to see.
Yeah.
Okay. Nothing else. We'll open up to the public. If there's anyone that would like to comment on supporting this or being opposed to it, they would come up and speak. Seeing and hearing none, we'll close that portion. And sounded like a motion over there almost.
Did you have a question? No, just make a comment.
Okay, so you push your button. Yep. And then we fire you up. 1 second. It's blinking, right? And then I light you up. There you go, David.
Oh, can you hear me?
Yep.
All right. Okay. Thank you for coming tonight.
Thank you.
So my question is, so your primary reason for requesting this variance is for visibility, correct?
Absolutely.
And because you want the business that goes there to basically do as well as it possibly can
should be.
in attracting customers, right?
Absolutely, without being overly huge. Yes.
Right, of course. So it's my opinion that it is. I can express an opinion, or only ask questions at this point, Chair?
No, you could do both. You can do both. Sure.
So my opinion is that in Malden, unfortunately, we have a issue with business vacancies, and we want businesses to be as successful as possible to obviously promote other businesses, neighboring businesses, as well as employ people and generate revenue for the city. So my opinion is being that this sign is primarily for practical and business purposes. I support a larger sign for visibility, and I walk that way a lot, and I know those businesses along the back are quite hard to see from Broadway 99.
All righty, thank you. Emily.
Make a motion to approve the petition. I'm motion to approve the petition for the reasons discussed.
All right, second? All those in favor? Aye. Adam?
Deny.
Okay. So, Catherine? All right, so it's approved by a vote of 4-1. Adam dissented. And thank you.
Thank you very much.
Okay.
Have a good evening and have a good holiday.
All right, we're going to do Lowell, and if you folks want to come up, I just need a minute to get set up here. Okay, and again, you think that was because of...
How do I turn this off?
You can just leave it on.
Oh, just, yeah.
Yeah.
Okay, so this is our second hearing, which is for 65 Lowell Street. It's the petition number 19-015 by Jordan Shipiro on behalf of Carine Cetoute, formerly Carine Vendryef, I hope I pronounced it correctly, seeking a variance from section 800.4.1.3 of chapter 12, the revised ordinances of 1991 as amended of the city of Malden. It's an administrative appeal we're here to hear and decide on the appeal decision in the orders that were made by the inspector of buildings, our administrative official. And it was namely that the use and occupancy at the property known as numbered 65 Lowell Street, Malden, which is also known by the assessor's parcel ID, map 80, block 363, parcel 323. And I believe it's Attorney Shipiro.
Thank you, Mr. Chairman and members of the board. My name is Jordan Shipiro. I'm an attorney in Malden. My office is at 105 Salem Street in Malden. I live on Gordon Street in Malden, and I was, for those of you who don't know my history, I was the city solicitor in Malden from 1978 to 98, and I can't believe those 20 years have flown by. But I'm still doing some legal work for some departments of the city. But for today, I'm here on behalf of my client, Carine Cetoute. She is the owner of the property at 65 Lowell Street, and she bought it in 1997. Now, I provided to your clerk a heap because I didn't think it would be fair to come in today without you having some idea of the documents that we have to support our petition today. And so just a little background on her. She has 4 children, 2 of which are seniors now at the Mystic Valley Charter School. She is a community nurse. She has an accounting degree. She has a bachelor's degree in nursing, and she has a cosmetology license since 1992. She did own a salon in Medford for many, many years, and now she no longer has that salon. She bought this property in 1997, and when she bought it, the basement had the walls and everything else that was that is presently there. And we had again, we provided the deed to you for when she bought it. When she closed her salon in Medford, she took some of the salon equipment to her home, and it is now in the basement of her home. She does not do any business from her home for strangers. She now only uses that area of some of equipment that she took for washing hair for her daughters. That's all she does, and she understands that she cannot do business without a permit. And she says that she has never done any business for strangers or for money for third parties at the salon, at the area that looks like a salon in her basement. She began to have problems with the city back in June 1st of 2005, and I attached an Exhibit 5 in my package to you that was a result of a counselor complaining. It appeared that she had no permits for any of the work that she did there. So trying to be a good citizen, she hired an electrician, and in July, Exhibit 5, she hired an electrician who she believes pulled permits. Again, unfortunately, there appear to be none in the City Hall records. She spent a lot of money, $2,700 in 2005, to have a lot of electrical work done. And she has a memory of somebody in the city coming to inspect the work after it was done. On August 1st, 2005, Paul Johnson, who was then in the building department, sent her a letter setting out violations. And I think that may be in some way related, but I'm not sure, to the June 1st, 05 notice that came from the building department that said there's violations. But anyway, it was a very formal letter. The first one is like a handwritten note. The second one in August. I don't think there was another violation. I think it was a follow-up from June 1st. And so Paul Johnson said, there's a long list of violations here. And my client wrote back in October 7th of 2005, which is the Exhibit 7, saying that she would do whatever she has to do in order to be able to keep the basement the way she has it. In October of 2005, she obtained an appraisal by a bank as she was applying for a loan. And in that bank's work in 2005, they noted that there were an additional 3 rooms and 1.5 baths in the basement. Now, what I think is worthy of focus is on April 5th, 2010, again, Scott Fitzpatrick, the building inspector, wrote that there appear to be some violations. He had a contact. And so and he came to her house after he sent out the notice on April 5th, 2010, and you see my Exhibit 11, which I thought was very important for reasons that I'm going to get to pretty soon. The reasons are very important because when he went there to inspect the property, and my client will tell you, he came in the house and in the basement and inspected the basement. And at that time, he found no violations, and the case was closed. You can see his own handwriting on the document. And that's because, again, my client said she thought that she had all of the permits and that had done everything legally. And that brings us, unfortunately, up to Mr. Miller, our good building commissioner here. And again, Mr. Miller and Mr. Fitzpatrick are 2 people that I know to be honest, hardworking, and very capable in our building department. And so I have reviewed this document with him, and again, what he said is the property is being, and I quote, illegally occupied. The basement must not be used as a dwelling unit of any kind. And unfortunately, my client has a son who had trouble and was arrested, and when he got out of jail, he had no place to live. And so for a short period in 2019, for several months, he was living downstairs in a bed in the basement, and that's what she will tell you when she has an opportunity to address the board, that she did what a mother would do for a child who had no place to live. So temporarily, he was living there. There's no doubt about that. We don't deny that. And it's obvious that there was somebody who was sleeping in the basement. That is not going on anymore and will never, ever go on again. The basement will never be used for a dwelling purpose. The other issue is that the garage area was something that she blocked off that garage, and again, that was done in 2004, and that was my Exhibit 3, where your contractor's bill that said he did work in the basement. And you see right on the check paid to him that that there was work done on the basement, and that was the work. She closed up the garage, and again, she left herself so that she would need to have a small car to park in her front of the garage. But that garage, Mr. Miller said, must no longer be used as retail service or business, and is not used for retail service or business, and it never will be used for retail service or business. She just says she does her children's hair down there, and it's a very nice place, and she works down there a lot. She is a nurse, and so she sometimes does paperwork and other desk work while she's down there to herself. And then there's, of course, there's a TV room and a bathroom and a small kitchen that she can do things rather than running up and down the stairs, because she is up on the second level. There's an apartment above her basement, and then there's another level above that where she lives. Now, I gave you some legal citations, and again, I understand that it may be something that needs to be referred to the city solicitor, but I gave you some legal citations from General Laws, Chapter 40A, Section 7, that gives the city 6 years from when they discover a violation to enforce if she got permits. And so that's something for you to decide after you hear my client as to whether or not you, if you believe that she did get permits, then I believe legally you don't have much choice but to hopefully sustain the appeal from my client. If you don't, then again, the time is not passed and that law won't apply, and it'll just be a decision as to whether or not you feel that my client's promises, and again, I would have no objections to, in the event that you were to overrule Mr. Miller to require that she does not violate any of those orders from Mr. Miller and that she gets other permits. But so I would hope that you'll consider, again, the history for 15 years. I don't really know it as intimately as my client, and so I'll take any questions, and then I'd appreciate it if you'll hear my client.
Okay. Adam?
So just so I understand, you're saying right now that the basement's not being used as a dwelling unit, is that correct?
Absolutely not. Correct.
And you're saying the garage is not being used as a retail service or business?
Absolutely not.
So you're not asking for an admin appeal of that portion. It seems like the basement, the work in the basement and garage is the basis of your appeal?
Well, the building inspector says we are, and that we are violating the city ordinances, and so I've appealed that in the hope that you will find, after you've heard all the evidence, that there is no violations going on now, and that you'll sustain our appeal.
All right. My other question, though, this is more on the legal side, is that
Sure.
my understanding is that the section you're referring to, the 10-year limitation,
6 and 10.
Well, the 6 year you need the building permit, and I think it
Right.
sounds like you don't have that. So to me that's out. That's not. I'm not going to. I don't really buy that right now.
Okay.
But the 10-year permit, though, if I understand, is all structural.
Correct.
Additions.
That I don't think applies to where the situation is. That is structural. Yes.
So yeah, that was the question I was asking you. Is if it work in the garage and basement, is there some case law that says that is a structural? What they're referring to as a structural work?
I don't believe so. I believe it's the use.
Okay.
And that would be under the 6 year. Again, I heard what you said insofar as credibility on the permits.
Emily? Sorry.
There we go. How did this case come before us? How did this come to the building inspector's attention?
At this time.
Yes, at this time.
Yes, I'll tell you how it applied. She applied for a third meter, a third electric meter for the common areas. And not being an electrician myself, I called too, and I found out that it's not unusual for someone who has a two-family house to request a third meter for the common areas, for the light on the porch, for the light in front of the house, for common stairways and things like that. And so she was having trouble with one of her tenants, she'll tell you all about it, that was costing her so much money that she said she needed to do that. There's also outside plugs for cookouts and things like that, and the fellow, I guess, was using up such an outrageous amount of money that she said, I got to get a separate meter for this particular location. And as a result of that, Mr. Miller, a little light went off in his head, I'm guessing, and so he said, not a good thing. And so that brought him with a violation, a notice, and the appeal.
I see, but to be clear, I think we've made this clear, that she's not seeking a third unit. It is
absolutely
existing
no.
units.
We don't have a prayer of getting a third family here. That's correct. She just wants to be able to use the basement for her family for purposes, for her own purposes.
Seems reasonable.
In a non-sleeping manner. I will ask in a moment. Mr. Miller will come up so he can maybe elaborate. I saw one other light for you, Jordan. Mr. Sullivan.
Yeah, just so I understand this, so the property was purchased in '97.
Correct.
At that time, were the two garages already closed in?
No.
They were not.
Correct. They were not. That was done according to what it looks like to me is 2004. 2004. That's correct, and we attached the bills for that.
Okay, and in 2005, could I ask the purpose of all the electrical work?
She got a notice in June 1st that the electrical was not legal, and so, as I understand it, she was trying to get that work done along with other electrical work in the house. Is that
Yes, that's when I pulled the permits, yes.
That's when she pulled the permit for the electrical
That
work.
was 05.
05, correct. And you saw the electrical bill, Exhibit 5, July of 2005, $2,700.
And how was it brought to her attention that electrical work needed to be done?
The notice of June 1st, 2005, given by the then building department. Let me just see Exhibit 3. I don't remember who signed that one, but that was somebody in the, wait a minute. Just 1 minute. I'm sorry, I messed up a little bit on my record. June 1st of 2005. It just says from the building. It looks like PJ. Looks like PJ did it himself. Paul Johnson.
Okay.
Right?
My final question is, what brought Inspector Johnson to the property at that time?
Somebody. Just 1 minute. I think it says so on his notice of complaint from counselor. That's on his June 1st notice.
But not the basis of the complaint, just a complaint?
That's correct. Okay. Well, I guess the complaint from the counselor, that's correct. It doesn't really say what the complaint was, but it does say, no, he just did a list of, owner was notified that no one can sleep in the basement, no permits for any work. That was his handwritten note, and I think that he just followed up with the August 1st, more detailed, typed up document.
Thank you.
So that's the reason, yeah.
Thank you.
Okay, did you want to address Mr. Shapiro, David? Yes. Okay, so let me just get you going. There you go. Okay.
Thank you, Mr. Shapiro, and thank you for your service to the city. What is your rationale to why the building commissioner stated that there was retail service being provided in the dwelling, or I'm sorry, in the basement?
Well, I'm not I try to avoid guesswork, and so he can answer that one, but I'm thinking that if you look at the floor, as the two of the visitors this morning did, you can see all of the indicia of what looks like a salon for doing business. And so I would say that that is something that if the building commissioner insists and you insist, we'll take that out. It doesn't affect really the content of and the ability to her to personally use the downstairs if those items were removed. But it's clear that when you look at it, you'll say, looks like it could be used as a salon. And what she said is that she took things from her other place, couldn't throw it in the trash. It was definitely used in a salon before, and so she took it home, threw it in her house, and was using it for professionally cleaning her own family's hair washing, that kind of stuff.
Right. Did you attach photos of the, what is allegedly a salon? Did you attach photos of the equipment and the apparatus?
I don't know if that is in the appraisal, but
It was observed today by two of us.
it was observed today.
Okay.
I mean, you can't.
It's something more than my salon, but it's certainly not something out on a commercial street.
Are there waiting areas or
No, I
is there
wouldn't.
a queue area or for?
I wouldn't characterize it that. It's
Okay.
subtle, very subtle and small scope.
Right.
It's
And-
just a chair to wash your hair, really, is all that's
I thought it was
there
about
with it.
300 square
Yeah.
feet out of 1,200 on that basement level.
And what you're stating is your client is using it as a salon for her own family in an unpaid capacity, correct?
Correct. She
Right.
washes her own family's hair.
Right, right.
She is as I said, she's a licensed, the word is cosmetology license, and she ran her own salon for many years in Medford Square, yeah.
Right.
So if I understand again, I believe that the citation from the building department, at least as I'm reading it, the first is use. They're complaining that you're improperly using it. The second is that the work that was done was without permits. And
Agreed.
I'm not. If you could touch upon the latter, I mean, what's your position? You saying that permits are no longer needed because of the time frame, or is your client willing to get those? If we say the use is okay, are they willing to get the proper permits for the work in those areas?
I very casually talked with Mr. Miller about doing that exact thing, is to send in her contractor that did the work, send in her plumber that did the work, send in her electrician that did the work, and make sure this time, I already told you, she said they all got permits, but nothing exists in the building department. And so, yes, that's a very reasonable suggestion.
So I understand it. You're not appealing the building inspector's citation that as of now she doesn't have the permits. Is that correct?
Well, again, if you ask her, she'll swear on a stack of Bibles that she thought she did. But I guess the answer is if you're asking if we physically have ever, do we now have a permit for any of that work? The answer is that we don't have permits, but we certainly have proof and bills. She's not hiding anything. She gave you all the bills that she paid for everything. She just, unfortunately, nobody has permits, and I'm not going to say I'm not going to guesswork about how that could have happened, but I would respectfully suggest that could have happened, that the building department misplaced or lost permits. I understand they moved and that is an issue for certain people. But I certainly cannot stand here and represent to you that my client has a permit. She just says that when she paid all these people, they were supposed to get permits, and she thought they did.
All set, Adam?
Yeah.
Okay, sorry. I am going to ask Mr. Miller to come up, but before I do, Jordan, you had made reference a couple times that you thought your client might want to speak. So my preference would be to have her speak before we invite Mr. Miller up.
I think that's a very good suggestion.
Okay.
Sure. Carine, do you want to come up and talk about why you think you are right?
And primarily, if there's anything new that we didn't, that your attorney didn't present, because he did a good job there and thorough, but looking if there's anything new to add that you want to present.
I just wanted to clarify in terms of the permits. This is the second time going around with the issue. If I had known that the basement was illegal or I wasn't in clear, I would never call the city to ask for a common area meter or a public meter. So as far as I know, back then, the basement issue with Mr. Johnson was clear. And they have come to my house on several occasions. I've done my kitchen. I've done work on the first floor. And all the meters are in the basement. And they've, like I said, the city have come more than 10 times to downstairs, the basement. So what I'm trying to say is, like, if I knew the basement things were illegal or I didn't, I would never invite them. I'm the one who invited them at my home. So I did pull permits when Mr. Johnson in 2005. So in terms of the permits, I thought the permits were pulled.
Okay.
So it was a surprise for me when Mr. Miller, but this and then, so.
Right, because this goes back to 04, that's almost
Yes.
15 years.
Yes.
Right. Okay. Anything else?
No.
Okay, thank you. I'm going to ask Mr. Miller to come up. Oh, I'm sorry. For our applicant? Yep. I thought I could get away without wearing these.
I have one question for you. Do you consider the basement as part of your dwelling unit? So it's part of your living space? It's connected?
Yes, it is, ma'am.
And it's only used for your family and your unit?
Yes, ma'am.
Okay, thank you.
Okay. Commissioner Miller. I think there may be a few questions.
I bet.
I certainly hope you might address, first of all, what precipitated why are we here. We're
Sure.
hearing about things a century ago, and
Yeah,
we're here tonight.
I mean, most of what Attorney Shipiro has conveyed to you guys is accurate. This was brought about this time around due to a application for electrical permit for a third meter, and our electrical inspector recognized the property. He's been with the city a long time, and he knows that this had come through before. So it's not very unusual. Inspectors, when they go out and see stuff, will come back to the office and say, "Hey, remember this place?" And then it leads to looking into it a little bit further. So just to clarify a couple things. So this is an administrative appeal, which means the question in order is was my violation letter correct or not? Not do we allow people to live in basements or whatever? Is the order that I issued correct, or do you think it's not? As far as the Mass General Laws, Chapter 48, Section 7, which I feel like we talk about a lot here at the Board of Appeals, just to be clear, that grandfather's work, and there's a 6-year and there's a 10-year statute of limitations. There is a 6-year statute of limitations on certain uses that are performed within conformance with the permit, special permit variance, but illegal uses are never grandfathered. There is no grandfathering, and that's what the basis of my violation letter is two illegal uses, one being retail sales in a garage and one being a dwelling unit in a basement. So Chapter 48, Section 7 doesn't apply to this whatsoever. Going back to the history a little bit, as Attorney Shapiro stated, Paul Johnson did go back out there in August of 2005 as a result of a complaint. He did issue a letter to the petitioner. It explained, I know you have it, but explained pretty explicitly that the two uses were illegal and were done without building permits. There was a letter then from the petitioner which
The two uses being the basement as a dwelling
the
unit and the garage conversion as a retail.
Yeah, he listed them both separately.
Nothing to do with the first floor and the second floor.
Nope. He listed them both separately and explained that they were done, that they were illegal uses for that property and that they were done without permitting. So I would assume at that point there weren't any lost permits, because if there was permitting, he would have found it back in 2005.
It wouldn't have called for him in 2005.
The petitioner then confirmed receiving that letter and says, I'm in the process of complying with those items listed in your cease and desist order. So the cease and desist would say, stop it and get rid of the retail service and get rid of the basement dwelling unit. And then there is another letter from Scott Fitzpatrick back in 2010, which states the same exact thing. There's no letter from the petitioner at that point that confirms it. And then there's obviously my letter from this year, which came about as a result of our electrical inspector going out there and seeing what was going on. So, as I had stated, the work without a permit is one thing, the illegal use is a different thing. The illegal use, the remedy to the illegal use is to get rid of the use. So, the illegal use doesn't mean there's actually people there using it. It means it's set up as a salon. The petitioner stated to me when we had a meeting not that long ago that there was a time when she was using it as a salon and she had stopped. We even spoke about how that had created some issues in the neighborhood, and that's where some of the complaints came from. Using it for your family doesn't make it any different. You're still using it as a hair salon. You're just doing it with your family. And occupying a basement as a sleeping area isn't allowed by ordinance or building code just because it happens to be a family member. You can't sleep in a basement. So as far as the permitting goes, I know we've been given copies of bills and checks, and I'm convinced, I'm sure that she did pay a contractor to do the work that was done there, but that doesn't constitute a building permit. Lots of people pay people to do work and they don't get permits.
May very well be the contractor's fault, but it's the
very well could be the
property
contractor.
owner's responsibility ultimately.
It is.
I just had a quick question about the dwelling unit. If it's connected to her unit and she uses it as she pleases, if there's no proof that she's actually using it as a salon or renting it out as a sleeping unit separate from hers, I would assume that it's okay because it's within her family, it's within her unit.
Are you speaking of the basement apartment, or are you talking about the salon in the garage?
I think I'm talking about both. A dwelling unit's defined as, a single unit, and if the basement is connected to her unit, whether it's on the second floor or not, it's still connected and part of her unit. So the basement plus her unit is the single dwelling unit, unless we can prove that she's been using the basement as a dwelling unit in itself.
So a dwelling unit is any space that provides provisions for eating, sleeping, food preparation, and sanitation. So if that basement has all of those pieces and parts, which it does, then it qualifies as a dwelling unit. It doesn't qualify as a dwelling unit because it doesn't have any of the life safety regulations you would need for a bedroom. It doesn't have a emergency escape and egress window out. So, no, I would say it doesn't matter if it's connected to her unit. It doesn't matter if she's allowing her son to sleep down there. It's not a legal dwelling unit.
Okay.
And it was never constructed with any kind of permitting.
Right. That aside, I was just trying to gather really the definition of dwelling unit and how it related to that space. So because it has provisions for bathroom and kitchen, that it automatically applies as its own separate dwelling unit.
Yeah, that's pretty much the definition of a dwelling unit. Once you have the ability to eat, sleep, prepare food, and clean yourself, you're a dwelling unit.
So if you're a single-family house on the same floor, you have 2 kitchens and multiple bathrooms, would someone draw an imaginary line and say these are 2 separate dwelling units, or would it be different?
in the city of Malden, we actually don't allow 2 kitchens in a single dwelling unit.
Okay, well, that's helpful.
And that's how you get away from it qualifying as a dwelling unit, is you've taken away the ability to prepare food.
Okay, great, thanks, that's helpful.
Emily?
You've answered some of my question, but I just kind of want to drill into this issue, if I may, for a moment. So, because she has a kitchen in her basement, she can't let her son sleep there, and she can't do her daughter's hair there? That I feel like I must be misunderstanding, because that seems like an incredible overreach by the city to tell her she can't do that in her own home.
So the garage was a garage, and then
It looks sort like, in this picture, it seems sort of like, oh, I messed it up. But it seems, I didn't go to see it today, but it seems to me more like I grew up in a split-level ranch, so what is the garage was sort of our first floor, and so, you know, my dad used to woodwork and whatever in it, and so this, like, basement garage first floor designation doesn't seem to make that much sense to me.
So
terms of functional
it was a
use.
garage. I mean, I think they
Okay.
just admitted to that. And then without any kind of permitting, they constructed a hair salon. So that constitutes a change of use, which is illegal.
They don't have
No.
life safety is part of building code, so they change the use, you have to get inspections to make sure that it complies with life safety.
For the use of sorry, can you just say that again?
It was a garage.
Okay.
Somebody turned it from a garage, took the doors off, put walls up,
Okay.
and put in all the pieces and parts to make it a hair salon.
Well, she said that she had a salon.
Right.
The lawyer told us that it was why trash it when you could use it at home.
Yeah.
That seems reasonable to me. Is there a reason that that's illegal?
Because it was done illegally. It would be similar to me saying I'm going to take the first floor of my house, illegally turn it into a bar, get caught, avoid the city for a little while, and then when I get caught, I say, well,
But
I'm
it
not
doesn't
going to
seem
let
like
anybody.
it.
I'm not going to let anybody in now. I'm just going to let my son and daughter go down there
It
and have
seems
drinks.
like putting a bar cart in your basement with 2 wine glasses and a bottle of whiskey. That's very different than turning your basement into a bar. And again, I work in the city during the day. I couldn't see the property, but it sounds to me like she was using, yes, salon-grade equipment, but to do the equivalent of a chair and a bar cart versus opening a bar. That you're allowed to use your own home for basically whatever you want, including, she says she does her daughter's hair.
Her attorney can answer that question, but
Okay.
what I heard when I was sitting here was that she's using it for her daughter's hair now.
But so
But
do you
she
have
told me.
evidence
But
that
she
she
told
was
me there was a
charging
time when, in matter of fact, that the source of the neighborhood complaints was
in that house, in
that-
that space, not that equipment, but in that space?
in that space.
Okay.
That there was a
And so
time
that's where
when
this complaint
the
came
neighbors
from?
complained because she was operating it as a salon.
Okay, as another point of clarification, so this, I think, is the first type of case I've seen like this, that it's, you said something that it's not a exception or variance or something. So, can you give me a little more understanding of what we're ruling on here, and if we
Sure.
grant the variance, what happens? If we don't grant the variance, what happens?
Sure. So an administrative appeal is when someone receives a violation letter from me and disagrees with it. So as opposed to a variance when someone is coming here and asking you for a reduced
The
side
usual
yard
thing,
setback or whatever,
yeah.
what you're essentially charged with doing is reading my letter and seeing if you think that my letter is accurate to what our codes and ordinances state. So if you were to, you're either going to uphold my violation letter or you're going to squash it.
And to take it a step further, if I may, so if we uphold your violation letter, we're just telling her you can't run a salon in your basement, which, if you believe her, she already knows and isn't doing, or
No.
is there more to it? And then if we, if we uphold it, does she get cited or fined in some way? Like, what are the stakes here?
The letter states what the remedies are. So
Okay,
she would have to
sorry.
follow through with the letter, and the letter states to remove the salon and to remove the dwelling unit from the basement. So that's what she would have to do.
So she'd have to take out the kitchen and take out the salon-style chairs.
Right.
I see. Okay. Okay. Sorry. Big case. A lot of papers that I had to
No,
read. and I read them.
I'm actually glad you asked that, because administrative appeals can get confusing as far as what it is the board is charged with doing. So,
Yes.
especially when you're used to granting variances.
Right, and they're not seeking a variance. We're acting
Okay, so
on.
we're doing the, okay, all right.
All
I
right.
think I get it. Okay, thank you.
All righty, I'm going to go to Mr. Sullivan. Not sure, Bill. There
You
you
hear
go.
me okay?
Yeah.
Yeah.
there you go.
In 2005, when Inspector Johnson was brought to the property and a cease and desist order was issued for both the living unit and the salon, correct?
Yes.
Was part of that order to remove both the salon and the living unit?
Yes.
Was that complied with?
No.
In 2010, when Inspector Fitzpatrick went or was brought to the property, he too issued a cease and desist order, is that correct?
I'm just reading it so I don't say the wrong thing.
Sure.
I don't believe it doesn't state cease and desist.
Was what Inspector Fitzpatrick observed at that time, was that ordered to be removed?
It says a review of our file show no permits are filed that will allow this, and that they're hereby ordered to contact his office.
Okay.
I don't have anything further than that from what he wrote.
Okay. And then finally, you were brought to the property, and forgive me, but
Just recently because of
correct,
the
the third meter, I
applicant
understand.
on the electrical.
Yep. So your sense with the appearance of the salon and the living unit is that it should be removed as well?
Yes.
Okay, thank you.
David?
Okay. So I have a few questions, but I just want to piggyback on what Fire Chief Sullivan asked you. August 2005, there was a cease and desist order issued by the city based on what Inspector Johnson observed. Is that correct?
That's correct.
And you just mentioned that that was not, they were non-compliance of that cease and desist order.
Correct.
Was that based on a follow-up after 2005?
A follow-up in September.
Inspection?
Yes, that they're both still set up the same way. There's still a...
So August 2005, it was the violations were observed, and then the order was issued, and then September there was the check to see if the work was done to take out remove the violations, and it was not.
Well, again, ours wasn't.
Right.
The purpose for our department going there was the electrical permit that she had applied for the third meter. The reason for the follow-up by a building inspector was the electrical inspector's knowledge of this ongoing situation and making us aware of it.
No, I'm sorry. I'm going back to 2005.
Oh, I'm sorry.
So in 2005, after the cease and desist order was issued, was there a follow-up inspection?
I don't know.
Okay.
I don't have any record of that.
So when you said that they were in noncompliance of the cease and desist order from 2005, is that based off of the inspection in 2010?
It's based off the inspection in 2019, which the two spaces are set up exactly the way they were described in the violation letter from 2005.
Right. I understand that that's 14 years later. So
Right.
how do we know that so it's the same setup, the exact same violations that were observed in 2019 were observed in 2005?
Yeah, so the order
Okay.
that was given in 2005 was to remove
Right.
the salon and to remove the basement apartment. So if that were complied with, they'd be gone, and they're not. So that's how we're drawing the conclusion that it was never complied with.
Now, what's the city's I understand that you've only been with the city for a few years, but what's the city's current policy? When the city issues a cease and desist order, is there like is there a time limit that says, okay, we'll give you this amount of time to, it's not the next day, right? I mean, you give them a certain amount of time.
There's no written policy.
And then
Violations are governed by state building code, and the follow-up time that you provide someone is basically off the discretion of the building official. So you wouldn't give someone 24 hours to remedy something where you're demoing a basement, you know. So the scale of the work that has to be done and the severity of the life safety issue at hand. The more of a life safety issue it is, the less time you'd give someone to do it.
Makes sense. So,
And part of that process is why we're here tonight. The applicant has the right to appeal Mr. Miller.
so I guess what I'm trying to figure out is, so they were non-compliant in 2005. The cease and desist order was issued. Did this city return to that property at some point in 2005 to see if the work was done?
I can't say.
Right, okay. And same thing, 2010, in 2010, was that also Inspector Johnson?
No, that was Scott Fitzpatrick.
Okay, Inspector Fitzpatrick, right? Okay, and Inspector Fitzpatrick observed these violations in
Yes.
2010.
Right.
And what was the reason that Inspector Fitzpatrick visited the property in 2010? What was the impetus for him visiting?
I don't know. I would assume a complaint.
Okay. And in 2010, a cease and desist order was issued by the city.
Well, as the deputy chief asked, his order doesn't say cease and desist. It states that they're in violation of, you know, the building code at that time, and that they were to contact his office to discuss that issue. So he obviously observed the violation and reached out to the homeowner to, you know, discuss it with them.
And was there any follow-up from the city that you were aware of
I don't know.
after 2010?
Not that I'm aware of, no.
Not until 2019?
Right.
Okay, so I guess I just don't, I understand with respect to you've been with the city only a few years, but if the city goes to a property and there's a violation, there must be a paper trail after the fact. Does the city return and see that the work was either done, not done, it was done, but it's improperly done, and where is that paper trail?
So in a violation like this where you're ordering someone to remove something,
Right.
what you would have them do is apply for permits to do that work, and we have a specific permit classification in our office called removal of illegal work. It happens so frequently, we have a permit named after it. So that permit, if the homeowner complied with the order, which it's their responsibility to comply with the order, not the city's responsibility to nag them about it. If they had complied with the order, they would have applied for that permit, done the work, it would have got inspected, signed off, archived, done, and we'd have a record of it. So that's the follow-up when you're removing work. That's the follow-up. There's a multitude of violations that we write, and some, you know, there's no permitting for. Some involves letters and you know, attorneys and things like that.
So there's a permit that the homeowner can apply for to remove the work that was done that was in non-compliance, correct?
That's right.
Okay. Now, if let's just say if your office issued a violation letter or cease and desist letter, and the person doesn't comply, is there any kind of progressive fines that are issued? Any kind of what's the punitive action the city takes?
So there's a you know, bunch of tools in the toolbox that we can use, and it really depends on the cooperation of the person you're dealing with and the particular circumstance. So there's no set playbook on how you handle a violation, but we can write you a monetary violation, and we can write those daily by state building code. We can, if it's something that involves life safety issues, we can actually take you up on criminal charges. So, there's a whole bunch of things available to us. Typically, what I would do is use monetary violations to motivate you to get it done, after giving you a certain period of time to fix it.
Right. And thank you for that. And the last question I had was in your letter. I'm sorry, I'm just trying to find it here in my email. Do you have a
Mine's back phone.
Do you have a hard copy of the letter that the building inspector issued in 2019?
He's looking
Oh,
for the,
okay.
is that it?
Did he get a package?
That's the most recent one.
Oh, okay.
You're looking,
Do we have the attorney's letter?
Yeah.
The Mr. Ship, the
Yeah.
65 page?
Yeah, I have it in my email. I'm just trying to find it here.
Okay. And I'll pass this down, and also Exhibit 10 or 11 will address a question you raised about why the city went out in 09 or 10. David, I'm going to come back to you, okay?
Sounds good.
All right. Emily.
So if the kitchen is evidence of this being an illegal dwelling unit, my question is, when was that put in? Was that pre-existing to this owner, or, yeah, when was that put in?
I don't know. There was no permitting for it.
Did you buy the house with that kitchen there? Yes. Okay. Also. There's no stove. Can I ask them questions, or do we wait until
Well,
after
for
Nelson's
continuity
done?
purposes, let's try to finish with
Okay.
Mr. Miller, and
Okay.
we still have this gentleman over here that wants to.
Yeah,
So,
okay.
you good for the moment?
Yep.
Okay. How you doing there, David? You ready?
So, currently in 2019, how many violations did the city issue to this homeowner?
Just that one.
Just that one violation, but there's two provisions in that violation? There's
It's one violation letter.
one violation letter
Yep.
stating that they must.
Well, from my department. I can't speak to anybody else.
Right. So can you read those violations that you issued in 2019?
You want me to read the sections that I...
The order that you issued to the homeowner.
The whole letter, or just the resolution to it?
The resolution, sorry. Just the action that they have to take.
Yep. The work in the basement and garage was performed without the benefit of a building permit. Building, plumbing, electrical permits must be obtained to remove all of the work in the basement and garage and return them to their original configuration. You have 30 days from the day of this letter to complete this work and have it inspected.
Okay, back to the original design. Is that correct? What you?
Yeah.
Okay. Thank you.
Yep.
Okay, anyone else for Mr. Miller? I know, Emily, you wanted to speak with the applicant, correct? Anyone else for Mr. Miller? No? There's a note from the attorney about why we went out in 2010. It says it was a former tenant complaint. It's written right on the top of Exhibit 10 or 11. Thank you, Mr. Miller. I think. Emily. Ma'am, could you come up again? Go ahead, Emily.
So, Mr. Miller, the building inspector, was saying that there is something that resembles a kitchen in that basement, and that's what sort of gave him the sense that that might be used as a separate unit. So can you describe that kitchen?
When I purchased the house, they were Jews and were kosher, so the kitchen was there. It was the second kitchen they were using. And also, can I make a quick statement?
Please.
I would consider myself a very responsible person. To receive a letter from the city giving me 30 days, if I don't comply, fines, $1,000 a day, I would never sit on something like that not to do anything. When I received the letter back in 2005, I went to my city council at the time, which is the mayor right now, and a good friend of mine who's the city council at a different ward. So they helped me out. I was young at the time when I had nothing about city ordinance or permit. So I explained to them the situation I was in terms of the shop bringing the equipment at the house. So they told me what I had to do. I wrote a letter, cease and desist. I'm going to comply with City Hall, which I did. I went in. The neighbor that had complained against me, we went into mediation in City Hall. We sat down, we talked. I explained to him, I'm not running a business. This is this and this is that. But I went in, pulled the proper permit, and did what I had to do. So everything, I thought I was in compliant with until in 2010, I guess a neighbor, actually it was my tenant that on the first floor, they were utilizing the basement. So they were at my house, they weren't paying me rent, so I had to evict them. And so they called the city on me. And they came again, and they looked, and as there were papers showing that everything, the file was closed. And what brought all this, I'm here today, Mr. Miller, all my permits, everything is missing. There's nothing in the file. So that's why we're here today.
And can you describe for me the salon-like equipment that's in your basement?
I have a setup. I have the sink. I have how would you put it? A styling chair. And I have a hair dryer. I have 3 girls, family members. I'm a licensed beautician. I'm a nurse. I tell people, I said, I'm a beautician first, versus a nurse. I work 70 hours a week. My job is very demanding. I'm not doing hair at my house.
That's for personal use, for you and your family.
Yes.
And as we all know, Nelson has a lovely head, but I would like to appeal to my fellow board members that I do think we should trust these women to know what personal use for hair care is.
Oh. I tell someone, it's like if your hair is not right, it doesn't matter what clothes you put on or how you look.
Don't tell me. He's sitting right there.
Well,
No, I'm kidding. Yes. Okay.
So, and plus being African American, it's a longer process. So it's like it's an all-day affair. So it's not a salon. I call it bonding time. So we would spend hours down there. It's like my girls, and it's just.
Again, I think that it seems reasonable to me, and I hope that it seems reasonable. And on this, I understand there's a few issues here, but having hair care things seems very reasonable for personal use. Yeah.
At this point, I mean, everything the equipment could go. It's not worth it. I mean, if that's what I have to do. Yeah.
And one final question. So just, your attorney did say this already, but just so that I can hear it from you, you remember getting permits for that electrical work? Not remember.
I went through a lot. The city put me through a lot in 2005. I went to the proper people, what I need to do, what I had to do, and I did. I did comply, and I did pull the permits, and now I'm finding out there's nothing in the folder. I didn't all this work. At this time, now, the work that I did then, it would have been $20,000 now, or $15,000. That was a lot of work.
Okay, that's all my questions. Thank you.
Thank you.
Okay.
Could I just make one
Sure.
comment? Just on the applicants on the petitioner side, and that is, again, from 2005 until 2019, no one cited her with a violation. If you take a look at Scott Fitzpatrick, who, I don't know how many of you remember him, but he didn't make, like Mr. Miller, they don't make many mistakes, these building inspectors for the city of Malden. A very bright guy. And what he wrote is, this office has received a referral from a neighbor regarding a possible illegal unit of the property. A review of a file shows no permits. And then the next thing you see, and it's indisputable, that he went there. Apparently he was satisfied that there were suitable permits for what he did. And in his writing, it says, closed, no violations. He went there 4 days later. And so, to me, that's very important. And number two, we're looking at it when Mr. Miller got involved. And it's clear when he got involved, from my client's testimony, and she's the only one here with the personal knowledge, that she was not using that basement for dwelling, and it's clear she was not using it as a salon to do people's hair. And so that's why I think you should find in favor of the applicant. And now we'll sit, and I think we may have...
Thank you.
Yes, thank you.
Okay, we're going to open it up to the public. Is there anyone here that would like to... I'm sorry. Okay, yep. Go ahead, Bill.
I don't mean to belabor the point about the permits, but just for point of clarification, it's been represented, I believe, at one point during the hearing tonight, that it was contractors that were believed to have pulled permits. And as it turns out, Mr. Miller doesn't believe that's the case. And if I understand your client just now, she said that she went and pulled permits.
The work, at the time, like I said, I had known nothing about permits, or I had my faith in the person.
I understand. That's what I wanted to clarify.
Yes. But when Mr. Johnson came in the picture, when I received the letter that it was an illegal basement, and I did pull permits again. Like I said, this is the third time going through this. I went to the proper channels, speak with the people that I should, and I did reapply, pull plumbing permit, electrical permit, just to prove that the work was done the correct way.
Well, no, you pull the permit before the work's done. You pull the permit before the work's done.
No,
that's the process. To do work, you apply for a permit.
The electrician that did the work, so I thought they did pull permit, but apparently, come to find out, they didn't.
Right, but you just represented, as Mr. Sullivan said, that in the initial one in 05, you pulled the permit.
Yes, yes. But the work was done in 2004. The worker, the letter that I showed you, the construction.
To document the exhibit that's already been presented. So she's saying, I guess, that she went in after she got the notice from him that there was the cease and desist letter from Mr. Johnson in 05. She then went in to apply for the permit for the work that had been done in 04. That she thought the fellow had gotten the permit, but apparently didn't. So she said she went in after. It's unusual. I agree with you. Normally you apply for the permit and then the work gets done. But here the work had been done, apparently without a permit, and then she gets the notice from Mr. Johnson, and she says she then went in and got a permit.
Okay. Mr. Miller, one more question. Just point of information. Talk about pulling permits, and I understand permit has to be pulled before the work is done. Can a homeowner pull a permit to do plumbing work, or does it have to be the plumber?
No. A licensed plumber has to do that, and a licensed electrician has to pull that.
So the only permits in this case
that his office would issue,
right, would be the removal permits, correct? And even they would be pulled by the people that were going to do the work.
Exactly. Any permit that would have been pulled to conform to Paul Johnson's order would have been a permit to remove the salon and remove the basement apartment. And one more thing about permits, when you pull a permit and the work's done and all signed off by everybody, when that work is complete, the homeowner gets a copy of they get the permit.
I understand.
We don't keep it. So you can put it in your own records and for situations like this.
All right, thank you.
I have a question actually for Nelson too. Nelson, am I correct in understanding that there's really two issues here? One is whether it's a proper use, and the second is whether she has permits for the work. Am I in the right ballpark on that?
They are separate issues. The primary issue are the uses. The uses are not allowed, and that's what takes the whole time frame out of the question, because illegal uses are never grandfathered. It doesn't matter who's using it. If you think a garage should have a hair salon in it, if you want your son to live in the basement, illegal uses are not grandfathered.
Okay. So it's fair to say then that I guess what I'm trying to get at too is that the work, even if she were to get the permits for all that work, it still wouldn't allow the use.
Right.
Yeah, that's what I thought.
Did you mean present tense, if she's to go get permits today?
Yes. Because I just want to make sure that I understand, because I see it as, and I think we're right, it's two issues, whether you can use it in the way that she's using it and whether she has the permits for it. But it sounds to me that if we decide that she doesn't have the proper use for it, then the permits really doesn't matter at that point.
Right. If her house today looked like it did 30 years ago, a garage and a basement, and she came to our office to apply for permits to turn it into a hair salon and apartment, she would be denied.
Thank you.
Yep.
Okay, David, one more time, and we're going to open it up to the public.
So I was not able to do a site visit today.
Who are we addressing this? Is it
To Nelson Miller.
Okay, you can sit down.
Building Commissioner. What makes you believe that it's for retail use? And does that matter at this point? Hypothetically, if you knew that she was only using it for her own family, not charging money, which actually her attorney stated was correct, would that still be disallowed?
Yes. What led me to believe she used it for retail use was she told me it was at one time, and that she no longer uses it for retail use, which could totally be true. That doesn't change the fact that it was an illegal use added to a building, that just because you now want to use it for your kids doesn't change the fact that it's an illegal use inside the building. And the sources, and the petitioner told us this also when we had our meeting along with the city councilor, that the source of some of those complaints was parking issues because people would come there.
Okay. Does it matter that let's assume that she's not currently using it for retail use. Let's just say that she's using it for her family. That you're saying that still is an illegal use, even if it's for her own family members who live there.
It is, because someday someone else is going to own that house, and they're going to buy a house with what they think has a hair salon in the garage.
Now, does it matter that the apparatus is in the garage versus if it was in, say, a bedroom or in a living room? Does that change the dynamic, or is it?
No, you can't turn any portion of your house into a hair salon.
Because as I understand it, sounds to me that this is commercial property. This beauty salon, this is commercial equipment, so to speak.
Yeah, it's not something you would typically have in your garage.
Yeah.
All right.
Good.
We're opening this to the public. Is there anyone here that regarding this particular hearing? Come on up. And we'd ask that you'd identify yourself with name and address, and if we need help spelling.
Hello. Thank you very much for inviting me here. My name is Charles Wasaja. I live at 69 Lowell Street, neighbor to Carine. And I know Carine more than...
Sir, we need you to spell the name for her.
The
We have to keep a public record, so we need to...
The first name is Charles.
We got that, but we need you to spell
the last name is an African name. It's W-A-S-A-J-J-A. J-J-A, like a Jewish. I live 69 Lowell Street. And I live there since 2006.
The other side of the court?
No, the same street. This is 65, 60, it's like...
Yeah.
And I know the neighbor more than since I moved over there. Even if this is my...
You know what?
I know Carine since
Okay.
since I moved over there.
Okay.
I never have any issue at all. Nothing.
Okay.
She clean outside. She clean our driveway. She cook for us sometime. And everything I hear right now, the neighbor complaining, it is new to my ear right now. I never hear that. My kids and they never hear that. And that's, when you talk about the salon, I work late sometime morning. I never see anyone coming out over there or just enter to the house for, like, most of the time. I think you do the women or men. Because I never see anyone coming out over there for getting out of the hair salon, like from the salon. Everything, and I go to the house, I see the basement, and I see the entire house over there. There's no way she used that basement for business. Zero.
How long have you lived in your house?
I live over there since 2006.
Oh, so you've been there a while, 13 years?
Kind of, yes.
Yeah, okay. Okay.
And everything I hear is new to me.
Okay.
This lady, she even...
Well, there was very little talk about neighbors and complaints. It was more about internal permits and...
I think...
yeah.
I don't want to say much. What I realize right now, because she kicked some people out of the apartment, people can create problems. That's what I can think right now. But the rest, according to me, zero. I don't have anything to say about the parking. We park everywhere. Sometimes even people park on our side. I go there and knock the door. Who's car for who? She say, oh, somebody live upstairs. I say, can you come and move the car to close? I can move. We don't have that issue over there. Thank you for your time.
Thanks. Anyone else that would like to speak? Sure. Again, just name and address if you would, please.
Patrick Barkhouse, Barkhouse, 42 Fairmont Street, which is the street next street over from Lowell Street. I've known Carine about 15, 16 years, and I'm mad at her right now. She got haircuts. I could use one. You go to the barber, it's ridiculous, you know. But she never told me she did hair, you know. I asked her one time about a haircut. She said, nope, only do the girls, so that let me out. But she works hard. I asked her one time to do something, and she said, oh, I'm busy right now. What do you mean? I just got off a shift, and the phone rang, and she had to go back to work. I mean, isn't that what this whole place is supposed to be for? People working and living, and you can't do nothing now. You can't even go anywhere and spend any money. And then they're doing a little, I'm not saying nitpick it, please. I'm not saying, but I understand what's going on. You see it all the time. But some ways there's got to be something to stop. That's all I wanted to say.
Okay, thank you.
Thank you.
Anyone else?
Excuse me. I forgot about that. I had open heart surgery, right? And she's yelling at me to exercise and all this other stuff. And she actually come by the house every day to make sure I was doing therapy and walking. And that's just the type of person she is. And beer, my friend. Thank you.
Okay. Hi.
William Tchate, 58 Malden Street. I just happened to be here today, and I actually wanted to share with you guys, especially with you, sir, on the permits. The fact that there are no permits doesn't mean that there weren't any pulled. I actually speak from personal experience. Back in 2009, I pulled permits with the city. In 2013, I was told I had no permits. I actually was able to bring them copies. If you go to my file, including violations that were cited, they're not in the file. I was able to bring back, Scott Fitzpatrick was the building inspector at the time. I brought copies from my house to them. They don't exist in my file. This happened twice. Also, that happened with electrical permits, which I didn't pull because the electrician pulled them. Plumbing permit, same thing. I was told I never pulled a permit. I was the one who actually brought the permits to the city. So the fact that there are no copies from the city I don't think should hold all the value that much, because I personally have had it happen to me twice where I bring in, and I had nothing, I don't know these ladies, I've never been part of this, but I had it happen to me twice where I'm told, hey, you never pulled the permit and I brought the copy, or I'm told there was no letter issued to you, or a letter was not issued to you, but actually I brought a copy of it, and I know that the city may not have had, prior to 2014, there may not have been all the record keeping might not have been all that. I don't know about after that, but I have personally done this.
So you kept copies of all your permits?
I have copies of most of my permits from 2009 to 2011.
Yeah, unfortunately.
And I've never pulled anything after that.
Okay, thank you. Anyone else? Okay, we'll close that portion, and would anyone like to make a motion? Emily, let me get you light up. There you go.
I'd like, no?
Oh, okay.
More neighbors?
Did they want to speak? No. Okay. Okay. Emily?
I'd like to make a motion to, I don't know how to word this, approve.
Well, it's not a variance. It would be either supporting the building inspector's violation notice or overturning it.
Okay, I'd like to motion to overturn it. I have great respect for our building inspector, and he makes great judgments. I just think in this case there's not enough evidence for the illegal use. I don't see it. And then I truly believe these residents are using their own residence for personal use and only personal use. With the issue of the permits, I have seen imperfect record keeping here in the city. There has been a city hall move, and I don't see enough evidence that there has been a violation. So in light of that, I believe we should allow these residents to keep their residence as it is.
Okay, is there a second?
I don't have a second. I do have a comment.
Okay.
I think that we're going down a very bad slope by overturning the building inspector here. An admin appeal is really where we look at the record and we determine whether or not Mr. Miller had evidence, if he had grounds for making the decision. It may not really be the decision I would make necessarily, but we're setting up a very bad precedent by saying that we're going to disagree with the expert unless we have really a firm grasp. We really have something that shows he had no grounds to make it. And I think he stated his grounds. So I feel very strongly that we should be overturning. Administrative appeals should be used only very sparingly, only under very high circumstances, and I don't see it here.
So you're not seconding?
No, I'm not
And
seconding.
we're doing the motion now, so we're done.
I'll make a motion.
No, I'm sorry, I was referring to just letting David know because we... So there's no second, and so that supports the building inspector's violation notice. We're not overturning it. That would be by a vote of 4-1. Okay, we're going to do Acorn Court. And I need a minute. Tim, I need a minute to get set up. No, you come up though. I think I have it in the file from a neighbor, two neighbors, one letter with two neighbors signing off. All right. 65 Lowell. All right, where was that? All right, this is our third hearing, and it is Petition 19-018 by Timothy Brash for a variance of Section 500.1.2.3, Chapter 12 of the revised ordinances of 1991 as amended, City of Malden, namely the off-street parking requirements for dwelling, 3-family, 4-family classification, minimum number of parking spaces, 1 per bedroom. And this would be at the plans that have been submitted, CMID 031529-2019 at the property known as the numbered 11-15 Acorn Court, Malden, also known by the assessor's parcel ID of map 78, block 354, parcel 430. And we are here with Mr. Timothy Brash, the applicant, correct?
Yes.
Okay. We applied, we advertised?
Yes.
Okay. Go ahead.
Yeah, so I purchased this property a little over a year and a half ago. It's currently 2 one-bedroom units, one above the other, and then next to it, sort of as a townhouse, 2-bedroom unit. There is no real yard to speak of. There are only the 3 parking spots, 1 per unit, that were there. There's no back or side yard. One of the units is in fairly poor condition, hasn't been renovated in quite some time. I'm currently, there's a permit in process for a contractor to renovate that unit. As part of that, given the layout and the structure of the unit, we're going to be making a large living area. There's a bedroom on one side, and there'll be another room. There's no real useful way to use the space other than making it into another room. So regardless of how this turns out, that is my intent, to make this basically a 3-room apartment. My hope is that I can legally call that a 2-bedroom. That will allow me to rent it to couples with a child, to individuals. It'll expand my rental market substantially for this unit, and will allow for a better return on my investment ultimately, when this unit is updated and in good shape with a much nicer, living environment than what it currently is.
Okay. So it's currently 3 units, and you do not reside there?
Correct.
And you purchased it recently. I have a few comments, but I'll open it up to the board members if there's any comments. No?
I'm sorry, what's the variance of? Is it a parking requirement?
Yes. So normally you'd have a parking spot per bedroom. Currently, there's only space for 3 parking spots. If there were more space, I would certainly add one, but there just isn't. I believe there's a layout lot plan as part of the application, which shows where the 3 existing spots are, and it's, I think, fairly clear that there's nowhere to put a 4th.
So there's 3 spots already, and you said it's a 2-unit building?
So it's a 3-unit structure, and there are actually 4 bedrooms currently, so it is grandfathered in with 4 bedrooms and 3 parking spots. So I'm looking to add another spot. Each one would be basically connected to each house, to each unit. They'd each have 1 parking spot.
So to add another bedroom, which constitutes needing another spot.
Of course, yeah. Technically,
From
I
the
think I would
existing.
have to add 2 spots in order to conform with the, if we added the bedroom, I would have to add 2 spots. One, it already has 1 more bedroom than it has. I'd also like to say it is, very centrally located. It's near a bus line, right on, I think, the 99, which I think will make it, and has made it appealing. There was a couple living in there before. They certainly weren't both commuting by car. I think for a lot of potential tenants, the location provides a lot of options for commuting that don't involve having a car.
And that would be the best case scenario, not to have the additional vehicle kicking around down there.
Yeah, absolutely.
Yeah. Okay. So it's a pretty tight, dense area. And the current building is on, I think, about 50% of the lot. It's just there's just no room down there. It's a small court to start with. The other thing is, it's listed now as a 3-family, and quite honestly, that's a stretch. Everything around there is really 1s and 2s, and giving you a lot size area, 3,100. A 3-family today is supposed to have like about 12,000, 15,000 square feet. It's so undersized. For me, it's a real hard sell to to be looking to increase anything, because you're so limited on what you have there. It's unfortunate, but, I see it a real tough sell for me, at least. I don't know if any other board members have questions or comments. Okay, David?
So the reason that it's currently one parking spot short is due to the parking requirements in the city changing from the time that it was originally built?
That's my understanding. The house is actually quite old. I suspect that it was on most of that land by itself when it was first built and has been subdivided down. When I purchased it, it was a 4-bedroom with 3 parking spots. I'm not sure when the parking ordinances came into effect. I believe it may actually have been since I bought the property. It certainly, has been in this state for quite some time.
Parking requirements have, generally speaking, gone up in the city.
That's my understanding, yes.
So as far as you know, there was no variance granted previously before you bought it. I mean, you may not know that, but
not that I know of. I'm not sure what. I don't believe that a variance was granted. My understanding is that it was already a 4-bedroom dwelling with 3 parking spots when the ordinances were changed for parking.
So it's pre-existing, currently non-conforming, yes, due to the ordinances being changed?
Yes.
Right. Do you have any, I understand this is primarily a rental property for you. Mm-hmm. Do you have any way to incentivize your tenants to use alternative methods of transportation, non-vehicular? You said it's on a bus lane, 99
yes,
bus.
It's on a bus lane, and it's a mile from Malden Center, from the T-stop itself. And frankly, it's probably even faster to go to Wellington on the bus as opposed to into Malden Center. My hope would be, I'm not looking to rent this out, for instance, to 2 couples as like 4 people living in a 650 square foot apartment who would have need for many vehicles. My interest primarily is to provide a comfortable living space that will work well for a young family or 2 individuals who are looking to live in a roommate type of situation. My preference, however, would be 2 couples or families. Previously there was a couple living there as a 1-bedroom, and I know that they moved primarily because they required an additional room for a child.
Right, and couples and families, I don't want to put words in your mouth, but your rationale being a couple may be able to possibly share a vehicle, and a family, obviously a child, would it be driving?
Right, certainly. Right, yeah, there would be a lower need for vehicles, and of course, from my point of view, it's not just the vehicles, but also, I think that's the sort of, my hope is that those are the sorts of tenants that will stay longer and, be an easier rental for me as a landlord.
Catherine.
The entire board has to consider 3 different sort of requirements in order to deem this
4.
applicant. 4? 4. All right. Well, 3. Maybe you can chime in the 4th one. 1, this improvement would need to prove, I guess.
No, more detrimental to the neighborhood.
Right. So there could be a potential for another vehicle, so that means you're 2 spaces short, so you have to prove that that's not going to be detrimental to the neighborhood. You also have to prove that the topography of the site is unique in some nature, size, or soil conditions, or other hardships that may be related to, the financial aspect of this build, but you're not actually improving the footprint, it's just inside, so like soil conditions wouldn't relate to that because you're not building like a new foundation. Mm-hmm. And the third, that there's some, financial hardship related to this. So say you bought the house and you can't rent it out for as much as you thought, and so you've got documentation saying that you need 2 bedrooms in order to make your mortgage payment work or something. Can you, did I miss one?
Fourth is the degradation to the intent of zoning.
Okay. So I don't know if you can sort of touch base on any of those. I'm sure if anyone's opposed or for, they can probably talk a little bit about whether you're proposing anything that would hurt the neighborhood, but feel free to touch base to try to convince us that you meet those 4 requirements.
Yeah, I mean, for the first one, my hope with all of the renovation and work that I'm doing on the property is to improve the neighborhood in general. You know, the current condition of the apartment is very poor. It is, you know, the carpets are quite old. The kitchen is unusable. Frankly, if I hadn't inherited tenants who wanted to stay, I would have done this as soon as I bought the property. You know, so I feel like, you know, overall I'm looking to improve the quality of the property and hopefully, ideally, the property values in the neighborhood as a result. As far as the restriction and my inability to meet with the current requirements, there's simply no space to put down another parking spot without tearing the entire house down. The house sits on the Acorn Court, which is a private way. There's basically no frontage in front of it. It is built to that private way. There are the 3 spots, and everything else is walkway. If you know, certainly, as I said, if there were any space where I could add even 1 spot, I'd be looking to do that. You know, for the improvement of the property, not just to meet this. Third, you know, all of these renovations, I've been doing heating and hot water throughout, renovating this apartment, and ideally we'll be doing some renovations on other ones in the future, although would not be looking to add any other bedrooms. This is certainly the most that you could, you know, reasonably fit in this space. Obviously, that'll be a substantial cost. My hope is that after this, I can refinance the house to extract some of the added equity and pay for some of these substantial renovations, and not end up, you know, having to take many years to sort of pay myself back for the investment. As far as the building codes are concerned, you know, I'm not sure that I can entirely speak to that. It's hard for me to understand the exact intent, but certainly my hope is that we can have less cars, generally speaking, around here as opposed to more, to ease congestion in the area. But without knowing the exact intent of the ordinance, it would be hard for me to say specifically that it doesn't go directly against it.
Okay. Anyone else? No? We'll open it up to the public. You can have a seat. Is there anyone here that would like to participate, show their support or objection? Okay. I did receive a letter, was asked to read it into the record, and this would be in opposition. It's from 2 neighbors, Steve Kelty and Jean Danton at 18 Clarendon Street. That's one of the neighbors. And the other would be Marie and Audrey Gautreaux at 17 Acorn Street. Our subject is on Acorn Court. Dear board members, and they speak in the plural here in the letter, the 2 couples. We have lived at 18 Clarendon and 17 Acorn for over 20 years. Our driveway is shared with 15 Acorn Street, across the street from where Acorn Court connects to Acorn Street. Acorn Court only has one egress, which is to Acorn Street. We appreciate the desire of the owner to have the office in the unit recognized as a bedroom, thereby improving the value of the property, and acknowledge the effort in submitting an appeal. However, there has been a long insufficient parking in the neighborhood around the intersection of Main Street and Acorn Street, as many residential units were constructed without off-street parking or insufficient off-street parking, and as Acorn Street has parking on only one side. Due to this insufficient parking, it is frequently the case that cars and delivery vehicles illegally parked in no parking spaces across from Acorn Court and also block our shared driveway. This not only causes frequent inconveniences to us and to the owners and residents of 15 Acorn Street, but this also presents a serious public safety hazard, as Acorn Court is a narrow and it is difficult for vehicles, especially emergency vehicles, to enter Acorn Court. Granting the request will grandfather the parking impacts to the neighborhood of this unit and make future mitigation of parking issues more difficult. We respectfully request that the request be denied. We thank the board. Okay. And we also received a second letter, and I'm not sure if it's in support or not. It is from the ward councilor of that area, Peg Crow, Ward 1, to board members. Once again, I thank you for the opportunity. I'm writing in regard to the property at 11 Acorn. I'm writing in opposition of granting a variance for off-street parking regulations for dwelling 3 and 4 family. If you have had the opportunity to inspect Acorn Court and the property, you will see that Acorn Court is no wider than 10 feet. Petitioner's parcel of land is only 3183 square feet. I often receive complaints that the tenants of the property do not use the current parking, but instead, you got to get me back to that. I lost it. There's no one paragraph left. I often receive complaints from the tenants of the that the tenants of the property do not use the current parking, but instead park on the court, restricting access to neighbors' properties. Granting the petition will open the door to exacerbating density issues and other significant violations. Granting the petition is more detrimental to the neighborhood, and I urge you to deny this petition. And again, this is Peg Crow, the ward councilor from Ward 1. No one else to publicly participate, so we'll close that portion of the hearing and ask if someone would like to make a motion. Okay, Mr. Sullivan.
I make a motion that the petition be denied based on the fact that the applicant or petitioner doesn't meet the 4 criteria of allowing a variance to be granted in this case.
All right, a second?
I'll second.
All those in favor? Aye. And aye. So we unfortunately denied it by a vote of 5-0. All right. What do we have? I'm going to do 58 Malden. Sure. If you find any water along the way, would you fill this up? Thank you. Okay, where am I here? Craig and Paul? Yeah, okay. Acorn. What am I doing? Okay. Thank you. All right, we're going to continue, and again, this is 58 Malden Street. Let me just read the ad, legal notice. We advertised?
Yes.
Petition 19-016 by Andrew William Tchate for a variance of section 800.4.1.3, chapter 12 of the revised ordinances of 1991 as amended of the City of Malden. This again is an administrative appeal, so it's administrative to hear and decide the appeal decision or orders made by the inspector of buildings, namely the use and occupancy at the property known as 58 Malden Street, also known by the assessor's ID of map 38, block 208, parcel 812. And I believe this is the property owner?
Correct.
Okay. And we have your name here, if it's spelled correctly. But did I do all right in the pronunciation? Tchate?
You did, Chat.
Yes, I did. Okay.
Yeah.
Thank you. Go ahead. Just summarize what brings you before us, and we'll go from there.
Sure. I'm the owner of 58 Malden Street. I live with my father, my wife, and my mother, and most of the year my sister. For a few years now, we've been having violations noted on the property, namely use and occupancy, number of residents, rooming house, several of them. Most of them stemming from, I believe, a specific neighbor complaint. Most of them. I have made public record requests to get copies of these complaints to be sure, to know who these neighbors are complaining now. Really, this hearing was a way for me to get that, and I'm happy I actually got the answers.
I missed that last statement.
This hearing for me was a way to confirm, confirm who those people are, and this was the only way and a cheap way to do that. But most importantly, the building inspector has made his decision, his determination based on a set of factors that I believe he has. I've actually met with him several times. He has his opinion, and I believe it's not accurate. But to me, that's during his visit to my house, the building inspector noted there are two violations noted. One of them, pertaining to this specific appeal, there's two things. One of the items noted was that there are more than two unrelated people living in the house. More than two people who are not related by either marriage, adoption, or this one more category I forgot. Or blood, thank you. During the inspection, the inspector met a total of four people. My mother, myself, my sister, and another person who was not related to us. How he came to that conclusion, I don't think there was a way to do that. And we actually have two units. This was in the unit in which I live. Upstairs, the second floor, when you guys came, you probably noticed unit number 2. On the first floor, I had a guest at the time. The tenant who stayed there was one person. There was a bunch of mattresses on the floor, and as a result, I believe that's what he said. That is what led to the position that this was occupied by more than two people who are not related by either of those categories. If you haven't met these people, how do you make that determination? And there was only one person at the time. Before he issued his order to cease and desist, they're gone now, so it's not even an issue. But before he issued his order, I went to the guy and I told him, hey, the building inspector was here. We walked into your apartment. You had several mattresses. What's going on? He said, oh, it's for production value. He was a film student. So how the building inspector came to that determination still puzzles me, because we met not a single person to be able to determine what their relationship would have been, if at all. There was one tenant. Now, the second issue, which is the use and occupancy. My home is it's a two-family house, classified as R3. I've been for the longest time, I was one of the biggest in the North Shore renters on Airbnb. Airbnb and I have had our differences for many reasons. And the way it works, based on his own communication to me, primarily you cannot the occupancy must be primarily permanent. It cannot be primarily transient. We make sure that we do not rent to people for the most part for less than 35 days, which is one of the reasons why Airbnb and I are not on the best of terms. in this specific unit, when Mr. Miller did his visit, the tenant who was in the house was at day 28 of about, I don't remember exactly how long he stayed, but he stayed for about 2 months. So how then do you tell me that the tenants are not primarily permanent? They don't have to be exclusively permanent. If I have 2 people a year who are not staying for 30 days, I don't think that qualifies me as breaking the city ordinance. Primarily permanent. His own observation was exactly that. The one time, anecdotally, and if anyone's been at my house today, part of the, if you focus on short-term rentals, I do short-term rentals only, and if you focus on 1, 2, 3 days at a time, you'll be booked all year. I don't do that because, one, I don't have the time. I have a few things going on. And 2, I just don't do it because it's not allowed. So we focus on those primarily permanent people. Mr. Miller in his email to me also stated that I have admitted to these violations. We met, if any one of you was, the ones who came to my house, there's a Nest doorbell. We stood at the front of my house. We met in the mayor's office, and I told them I do short-term rentals. At no point did I tell anybody that I do mostly 3-4 days at a time. We do short-term rentals, but these are not 3-4 days. We're focused on 30 days or more. They're a little bit more complicated because then they're tenants as opposed to guests, and also it prevents you from going through the most common channel, which is Airbnb, but as a result, we just have less issues. You have less turnover, you still keep the same income that you're trying to get, which is the higher income from short-term rentals, but you have less turnover and you have less issues to deal with the number of people. So there are 2 separate violations noted, and for the second one, where it states that there were more than 2 unrelated people, I believe that's just clearly not true. There was 1 tenant at a time, 1. And Mr. Miller would have had no way to ascertain any relationship between anyone at the property because he did not meet anyone. And for the second case, I understand what the point is. I get that. Many people are not okay with it. Before I started my journey on short-term rentals, I met with every one of my abutters. No, most except for one, the one directly across from me because I have no relationship. I met with all of them. I spoke with them. We've had issues. One of the biggest issues that I've had with my neighbors was parking, because people who would come back then with Airbnb would actually take up parking on the street. We didn't have a lot of parking issues, but starting about 3-4 years ago, Malden Street has become very crowded. So I got that. And what we did to resolve that is, first, we have people who stay mostly permanently. Many of them do not have cars, and when they do have cars, they park in my driveway, especially on snowstorm. If you come to my house during a snowstorm, you'll see at least 4 cars. It's a 2-car driveway. We make it work. During any snowstorm, we clean the street for the neighbor. Eduardo Grafals, the guy in the back, who had the issue with parking, we make sure that my car will be on the street during the storm, and we'll move it in. It's just easier for the person who's going to park there. We don't do any of the space saver business, none of that. I've been in the street since 2008 when we bought the house. We've been there. I've never had a neighbor who's come to me and expressed a concern that I have not addressed. It might not be addressed to their resolution, as well as I may not meet 100% of what they want, but every neighbor who's ever come up to me has always seen their concerns addressed, and I'm happy that I'm here today because it allows me an opportunity to see all the neighbors who, for some reason, may be afraid to come up to me. Thank you for the time and consideration.
Okay. Questions? Okay, I just have one. AMI.
Yes.
The documents submitted to the Secretary of State say AMI is engaged in short-term rentals and other activities.
Correct.
Can you describe other activities?
Import and export business. I am very focused, actually, which is the bread and butter of my activities. I'm focused on export to Nigeria. I work as the procurement agent for a lot of people in Nigeria, which forces me to travel down to Abuja quite a bit every year.
Okay.
So I work as a procurement. If you want to buy something, so mostly cars.
The import-export activity doesn't really have any basis at Malden Street. It's just the administrative address?
Yeah, that's
You don't have the product coming in and out and with FedEx?
Everything goes mostly through a warehouse in Texas, shipped to my door. You can look them up. I work mostly with them. Goes straight from my door to Abuja or to Niger.
Okay. But the other, what you submitted back in 2016 to Secretary of State Galvin, the corporation will engage in short-term rentals of real estate and also do other business activities as permitted by laws. It is a multi-purpose corporation.
Correct.
Okay. Anyone else?
If you come twice a month, once every 2 months, I go down to Nigeria because I have to go follow activities down there.
Okay.
But I'm originally Cameroonian. It's just where my business happened to be.
All right. Okay, go ahead, Emily.
I'm a little confused. Have you terminated your relationship with Airbnb at this point?
No, it's not terminated. I just don't list my
You
property.
don't use
For
it?
the most part, I'm unlisted. If you go right now to the property, it's unlisted. I'll once in a while list it. It happens especially for stuff like Marathon Monday, Marathon Weekend, those types of weekends, but otherwise, no.
So how do you currently find these 1 to 2 month tenants?
Oh, I have different ways of sourcing. One of the best ones is Facebook Marketplace. If you go on Facebook Marketplace right this second, you'll see my ads. I am always on there. And Malden is not the only city I work in. I work in several cities. Remember, at one point, I was the biggest Airbnb in the North Shore. There's other people who have been bigger now, obviously. I have several properties. I make sure that I follow the laws. I read those texts. I don't play games with when it comes to that. The threat of fines doesn't deter me. The threat of being a bad neighbor is what deters me. If I have a neighbor who complains and comes up to me, that's what I pay very much attention to.
And is there a reason that you advertise these for 1 to 2 month rentals instead of renting for what is more common, like a 12-month lease is more common?
Money, straight up. It's a lot more money. If I rent in Malden a 2-bedroom, I'll rent for about $1,900. I do $3,000 to $4,000 a month. Money, straight up, that's it. Okay. And it's rented, it's furnished, and I know how and where to source. Facebook is one place, not the only place.
Okay.
Thank you. I'm going to ask our building inspector to come up if no one else at the moment has a question or inquiry. Mr. Miller, could you give us your synopsis?
So we were brought to this property by a neighborhood complaint, and the complaint was that it was suspected to be used as a short-term rental. We issued a letter to the owner, request to inspect, which he wasn't pleased with. As he said, he and I met. First time we met, we had a meeting that he requested in the mayor's office with the mayor. At that time, he told me he was using it as a short-term rental. He told me he had people there for less than 30 days, and he also went on to explain to the mayor and I that essentially it's his property and he'll use it as he sees fit. The only resolution that came out of that meeting was that he agreed to allow us to inspect it, which he had previously denied. Typically, when people deny us inspections for periods of time, that usually means they're doing something wrong. People who are doing nothing wrong usually don't deny inspections. So I went out there personally instead of sending one of my building inspectors. I met with Mr. Tchate, and that's when I observed in the second half, the left side of the building, multiple mattresses. One was even out in the middle of the hallway somewhat. I didn't notice any film crew equipment or anything that looked like a Hollywood stage, so it didn't look like any kind of filming was going on. And at that time, Mr. Tchate was somewhat evasive in saying whether or not the people that were there were related to each other or not. He kind of conveyed to me that he had no idea who they were or how they knew each other. The violation letter was written based off of the information that he gave me verbally about his own property.
All right, and the violation is the manner in which you believe he was operating the property?
The manner in which I believe and the manner in which he told me. He's, as you saw, he's the biggest Airbnb user in Malden or whatever. A short-term rental, it doesn't matter if one person rents it or if 5 people rent it. That does transient occupancies aren't allowed. So short-term rentals are not allowed through building code. And then
the definition of short-term?
Occupying something less than 30 days.
Okay.
There was never any claim or statement that it was being rented for
less or more
30, 60, 90 days
Yep.
at a time.
Okay.
So then the occupancy goes back to the no more than 2 unrelated people allowed a dwelling unit.
All right, Emily.
At the risk of antagonizing you again, I really do respect you. But what is this violation has, it seems like two separate issues.
Mm-hmm.
One is this sort of Airbnb type rental, and the other is, can you say what the other one is? Is that related to the first issue, or is that how he's occupying his unit?
No, his unit is being occupied. There's no issue with the way he's occupying his side because, I think we've probably gone over this a million times, but our ordinance states that a family constitutes no more than two people who aren't related by blood, adoption, or marriage. For example, his side of the house is him, his wife, his parents. Those are all people who are related by blood, adoption, or marriage. When you get to the other side of the house, you can't have more than two people there who aren't related. And
so the issue is the short-termness and also how many unrelated people.
Right, they're separate things.
So nothing was about him and where he's occupying. It's all about the other unit,
No,
but then there's two things wrong with that.
Right, of the two-family home, there is nothing wrong with his side at all. It's the side that he's renting out, right.
And how many people did you see there?
I didn't see any people there.
But you saw a bunch of mattresses.
I saw a bunch of mattresses and requested, and his answer was, well, I think there's three, and I don't know who they are or if they're related to each other.
And just to be clear, they're not side-by-side duplex, they're up and down.
I'm sorry.
Gentleman's on the second floor. The unit that we visited and that's in question is on the first floor.
Yeah, I'm sorry. I was referencing the doors, left door,
No
right
problem.
door.
Adam?
Is he permitted to rent it for 30 days or more? Is that okay if that was what he was doing? Is that permissible?
Yes.
And I'm sorry. Let me just follow up. And what would be the implication of this order? Is it just a cease order, or does that mean he has to stop altogether?
Yeah, just stop renting it in that way. Yep.
You have to excuse me, this is actually my first night, but so currently, City of Malden does not allow traditional Airbnb that's less than 30 days?
Right. I prefer the term short-term rental.
Short-term rental,
because there's
right.
a whole bunch of them. Airbnb is obviously the most common one that everyone's heard of. But yes, so our through a combination of our zoning and our building code, a short-term rental of a property is not allowed unless it's a hotel or a motel.
Right. Now, he told you, the owner told, the petitioner told you verbally that he was using it for short-term rental?
He did.
At that time, during the time of that conversation, was short-term, was the criteria of short-term defined, I guess? In other words, could he have said that I'm using, he just told us that he is using it for rental that's more than short time, for over 30 days. Could there have been a misunderstanding when he told you that? So, I mean, look.
Can you turn me on? The owner just said to us right now that sometimes he doesn't do that. He just used Marathon Monday weekend as an example. So I think that's not up for debate, that at least at some portion of the time it's less than 30 days.
It's used in that manner. Okay, David. All right, I don't see any more lights. We'll open it up to the public. Anyone here to speak in favor or in opposition? Hi.
Hi.
So usually we'd like to get name and address.
Mary Martins, 304 Pearl Street.
Okay.
Right on the corner from that Malden Street.
Okay, Martin, M-A-R-T-I-N-S.
T-E-N-S. T-E-N-S.
What number, Pearl?
304.
Okay. All right.
I've lived there all my life. I've been in this neighborhood all my life. I've seen the changes, and they're great. I have great neighbors, great area. I hear about this, and it really gets me nervous because, gentlemen, I just found out that you do reside there. He resides there, which is great, because I thought you did not. But renting to these multiple people over short periods of time, is there any kind of background check on these people? Any kind, is that when renters come in, you usually have some kind of information on them? There's numerous cars on Malden Street that are out of state, constantly parked. There's no parking in the area. They come to Pearl Street and park, then we have an issue there. And I'm here tonight because I need to, I can't see this going on in the neighborhood. There's more than one going on in the neighborhood with these rentals. So
All right, if there's others that concern you, you should pass.
We spoke to Mr. Miller tonight.
You
as a
should
matter of fact.
pass along
I've called.
something written, and that's always helpful.
I've
As
called
you've heard
City Hall
tonight, it's good if
numerous
things are
times.
written.
Numerous times.
Okay. All right. We'll give it another shot.
But I don't know if you want to say anything. But, yeah.
Same address?
No.
Okay.
Gail Greenwood, it's Gayle. I live at 275 Pearl Street.
Okay.
That's the corner of Malden Street. My back door is diagonal to 58 Malden Street. I see it every day. I've lived there for 60 years. The house has been in my family since 1890, so I'm an old timer. I have seen numerous people going into that left-hand door at 58 Malden Street with, little, not with a lot of suitcases, like they're going to live there for, 6 months. I mean, with little backpacks or a little, wheelie thing. I've seen them walk in with a rice cooker, and then the Ubers pull up, because most of them I haven't seen driving their own cars. But I've seen Ubers drive up, they get in the car, or they walk to the T with their little wheelie things, and then, a week later, I see new faces. Most of them look like Asian people. So I figure, maybe they're students and their parents are coming to visit for a week or two. But this is constant. I mean constant. The woman that lives behind 58 Malden Street, it's 58 rear, she had to have the city come down and measure in front of her driveway, because there's always cars pulling in and parking there, and she can't get out. I don't even know who the woman is, but I know the story. So they had to put up a no parking sign. She's on Malden ClickFix every day. Someone's there, and by the time the police come, the car's gone. So I've seen them come out of the gentleman's, house, the left door. I never see the right door. I've never seen him, to tell you the truth. But that doesn't matter. I mean, God bless him, he's my neighbor. But I didn't know that you were allowed even to have short-term rentals in Malden. I thought you had to have some kind of a, license or something. But, this is constant, not 6 months. I'm talking, it feels like forever. But it's been a few years. And I mean, there's not just two people. There's 2, there's 4, I've seen 6. I'm telling you, it's crazy. Nobody, I'm glad he lives there, but most of my neighbors, I don't even know. That's why no one's here. They're all renters. The owners don't live there. I have to call my counselor to tell him that I'm not cutting the grass next door anymore because my neighbor sold the house. I used to do it for him because he lived in New Hampshire half the year. But, I mean, the grass was this high.
We want to stay on 58, though.
Yeah.
Okay.
So, I mean, I don't know what's behind his house. I'm just saying it's crazy. That house is in and out, in and out, in and out. I don't know what's going on.
Okay.
And the mattresses on the floor is concerning. I mean, I thought it was just maybe, a family or two. A family that went in and slept in the 2 bedrooms or 1 bedroom, but mattresses on the floor? I mean, come on. This is unacceptable in Malden. Malden's got too much going on. So I just want to
Okay.
say that.
Thank you. Anyone else? All right. We also have two letters. Both of them are in opposition. I'm sorry. Both of them are in support of the building inspector. I'm going to read them in. They both are from city councilors. First is the gentleman that you referenced, your city councilor, Mr. Paul Condon, who represents that ward. I apologize, board members, I apologize for not being able to attend tonight's meeting. I would ask that the following be read into the record. I am against the administrative appeal filed by the owner of 58 Malden Street. Our building commissioner issued an order to cease and desist to stop the owner from continuing to rent living space to as many people as he wants at said address. The owner has ignored the cease and desist, which has resulted in the continuance of over-occupancies at this property. The owner has admitted to the building commissioner that he is using the property as described above and intends to continue to do so despite the cease and desist. He maintains it is his right to do so, and I strongly disagree. Please deny this appeal. And again, that's Councilor Paul Condon. The other one is from Councilor Craig Spatafora, Councilor at Large in the city. Dear board members, Malden continues to grow. Demand for housing has led to a dramatic expansion of the city's informal housing market. The city continues to be made aware of hundreds of illegal rental units across the city. As rents rise, so do the number of illegal units. These units are not just bad for the city, it's bad for the neighborhoods and tenants of these illegal units. They are more variable to fire and safety hazards that arise from the lack of municipal regulations. While most citizens understand the importance of fire-suppressing safety measures, many more are likely unaware of the risk or choose not to deal with them out of economic self-interest. Illegal housing/rentals are an issue that I take very seriously in the city of Malden. Malden is committed to halting the proliferation of illegal housing conditions that are substandard and or in violation of the city ordinances. Such conditions overburden municipal services, schools, and result in the deterioration of our neighborhoods. The petitioner, Andrew Tchate, has admitted to renting his home, which is a clear violation of regulations. Government regulates all aspects of business and industry to preserve the health and safety of its citizens. Illegal alterations are frequently done in violation of existing fire and building codes and constitute a significant danger to tenants and other individuals living in the building. In addition, fires that begin in homes with illegal apartments or alterations pose hazards for first responders, such as fire, police, and ambulance. Illegal housing affects residents and homeowners by negatively impacting their quality of life. It places a burden on many services provided for residents, causing the overcrowding of homes, creates life safety issues, and in some cases negatively impacts property values. Illegal housing prevents the proper inspection of homes required to ensure a safe environment for both residents and prospective tenants alike. For these reasons, I'm requesting the board deny Mr. Tchate's appeal. Allowing this petition to continue would send the wrong message to the neighborhood, property owners, and encouraged residents and community stakeholders not working with the building department and law enforcement personnel to identify homes that have been converted into illegal occupancies. Again, that's Councilor at Large, Craig Spatafora. No one else to speak in the public hearing, which will close, and would there be a motion?
I have some questions for discussion. Is that allowed at this point? Okay. So the petitioner admitted that he is at times doing short-term rental. So is that currently the issue is that because short-term rental was disallowed in Malden, so if the petitioner agrees not to do short-term rental but do longer-term rental over 30 days, would he be in compliance?
Mr. Miller.
Yes.
Okay. So as long as
he's being asked to do two things.
Okay.
One is to not rent the property as a short-term rental.
Right.
And when he does rent it to either a group of people who are related by blood, adoption, or marriage, and if they're not, only two of them. So compliance with our ordinance defining a family, and conformance with the building code, meaning don't turn it into a hotel.
So the letter from Councilor Spatafore talked about putting a burden on schools and being in a legal apartment. In terms of fire safety and structural safety, is Councilor Spatafore's letter that was read into the record talks about the legality of that dwelling? Is there any issue with egress safety, fire protection safety, anything related to that, or is it simply the fact that there's more than two unrelated people living there and in short term?
Just like any building, if it's occupied correctly, then it's safe with regard to how it's currently constructed. So if it were occupied by a family or a group of two people who aren't related, no more than two people not related by blood or adoption or marriage, then there's no issue. There is some correlation between illegal occupancies and danger when it comes to fire. I'm sure the deputy chief can expound on that greater than I can, but the basic premise is that if I'm in my home with my wife and 3 kids, I don't have 3 kids, but if I had 3 kids and there's a fire, I'm engaged in getting them out of the house. If I'm in a dwelling unit with 4 people that I just met or don't know, or maybe we're kind of friends, maybe I'm going to get out and we'll see what happens to them. So that's the reason for some of those occupancy rules.
So the apartment's not illegal in terms of it doesn't have it's the apartment itself is legally permitted, correct?
There's nothing wrong with the apartment. It's
Okay.
a two-family house. Like I had stated previously, Mr. Tchate is occupying his side with no issue whatsoever. The problem is the occupancy of it. So using it as a short-term rental is one issue, and putting more than 2 people who aren't related by blood, adoption, or marriage. The order I gave him was to stop doing both of those things. No other.
And when you asked the petitioner to stop doing those 2 things, it was made clear that he could continue long-term rental at that location as long as it's not more than 2.
I would let him speak to what he
Okay.
understood from that conversation.
Right.
Yeah. I know that I certainly explained these same rules and ordinances as I've explained them to you.
But his response was no to you.
It's my house. I'll do what I want.
Okay. Thank you.
Thank you, Mr. Miller.
Can I just say one thing? I think my...
Use the mic, sir. Anything new, or you can respond to the latest?
It's just responding, and I think my comments are taken out of context. On this letter that I received from the commissioner is dated on the September 16th. On September 13th, I sent him a clear email, so the statements are not true. I want to make it clear, and I wrote it by email so there's no confusion. I never said that I am not renting. So the ordinance is clear, primarily transient. I do not primarily use for transient purposes. I have occasional transient use, but that's not disallowed by the regulation, the way it reads based on what I have read and what he has provided. And I never said I'm going to use my house as I please, but I also said I follow the law. And this is in writing, so there's no confusion. As to the responses to all the questions, they are all in writing, so if there's any confusion, please pull up the email. It's in writing. I said it very clearly. There was 1 person in the house. We primarily use for more than 30 days. So there's no question as to what I said. There's no misunderstanding. It's in writing. I have an email dated before the violation notice. Before, so it's not like I came after the fact. Before, as well as the conversation in the mayor's office. So all these things that you're hearing, I put that in writing to make sure that this specific thing that's happening doesn't happen. It's in writing what I said. If anyone has a question on that, please refer to my email, in writing, so there's no ambiguity. Thank you.
Thank you.
So it sounds like the petitioner is saying that he primarily uses it for longer term rental. So why don't we just? Sir, are you at this point? This point, do you understand that short term is disallowed in the city of Malden?
Absolutely. And
okay.
And I follow that absolutely.
So and you mentioned Marathon Monday, and that was like occasionally do it for short term. Okay. So will you agree to no longer rent it short term and only stay in compliance by renting it in a longer term capacity and to no more than 2 people that are unrelated?
Exactly.
So what we're voting is to uphold what the building commissioner said, which was absolutely no short-term rentals.
And I'm saying
so that's what we're voting on. So to narrow our scope, it's your first meeting. So to narrow our scope, we can't ask him to do things. So with this thing, we're gonna vote to either
uphold or
it
overturn the building inspector's ruling.
So Mr. Miller said already his 2 conditions, which are nothing under 30 days and no more than 2 unrelated people. So that's what, if we choose to overturn that.
I understand that.
Then, okay.
But if you agree, why are you appealing this?
As I said in the beginning,
he doesn't agree.
Appeal is not. Well, yeah, in the sense that I believe that occasional transient use is okay. But in reality, this appeal to me is not about an appeal. I want to make that very clear. This appeal is about meeting these people. This is what this appeal is about.
Sir, we can't hear about occasional use.
I'm sorry. No. I'm saying my
public hearing has been closed, first of all, ladies and gentlemen.
So this is what that's it. So my position is very clear.
Thank you.
This was all this hearing was about.
We appreciate it. Thank you.
It sounds like
David, we're done. Bill?
I make a motion we uphold the building commission's directives.
Second.
All those in favor? I agree. 5-0. We're upholding the building inspector's violation notice. All right. Home Street will be up in a moment. How do you know that? All set, folks?
Yeah, thank you. Thank you.
All right. 27 Home Street. Petition 19-017. By Syed Shabbir for a variance of Section 800.4.1.3, Chapter 12 of the Revised Ordinances of 1991, as amended of the City of Malden. Again, administrative appeal to hear and decide on the appeal decision in order made by the Inspector of Buildings or other administrative official, namely the use and occupancy at the property known as at number 27 Home Street, Malden, which is also known by the Assessor's Parcel ID of Map 144, Block 677, Parcel 704. Hi.
Hi, good evening. My name is Silvana Shakib.
We're going to probably need a spelling for her, please.
SALVANA SHAKAIB.
Address?
27 Home Street. Oh, my home address is 0 Davida Road.
I'm sorry, again?
0 Davida Road, Burlington. That's our home address.
Okay, did you get that? Okay, I'm sorry. 01803. Okay.
Before I begin,
sure.
Am I allowed to give some artifacts?
Absolutely.
All right, thank you.
Okay, thank you. Oh, great, thank you. We advertised, right? be advertised.
This is the letters from the city and my letter back to them.
Okay.
I think it might be
That's it. We have that in our package, don't we? The letter from the city and the response from the applicant back. Okay. With respect to the leases that you're giving me, are those current occupants?
Yes.
And leases plural, meaning they're multiple?
They're 4 people.
4 different individuals? Okay.
And this is some proof of their monies that they pay me as rent. This one, I can talk about it too. This is just going back, like a couple of them. One of them at least has been with me for 3 years. So I took out from the bank today. They could give me back 18 months. So this is
Okay.
what I have. So I just wanted to put it out.
I appreciate it. And with respect to the leases, that's 4 different individuals?
That is 4 different
Okay.
individuals.
Currently occupying?
Currently.
Okay. Great, thank you. And you're Syed?
Yeah, that's
Okay.
right.
Yep, same address?
Same address.
Okay.
So, I just want to apologize before I begin. I know I've been creating some confusion there, but that's my son, and he just heard some very bad news about his friend. So we're going back and forth. So I apologize if I get emotional anywhere.
Okay.
But did you want me to summarize and
So,
start?
yes, if you would, please.
Yes. So this started sometime in June. Okay, so we own this property, 27 Home Street. We bought it in 2004, and I raised my kids over there. And then in 2012, we moved to Burlington. We bought another house. So this is our only rental property. Me and my husband, we both work. I work in Quincy every day. He works in Watertown. We drive back and forth all day long. This is, I'm just trying to make the fact that I don't own too many rental properties. I'm not into the rental game. This is just our one property, and where I'm trying to bring my issues here is just to give you a backdrop of why this is so important to me. I have 2 sons going to college. One is going to college. The other one is in the senior year, and he's in the middle of applications and all that stresses. In all this, I have 4 people that I rent to. I have a 5-bedroom apartment. There's 4 people renting, and they are leases. They've been with me for, I do like a 12-month rental, and these people started with me. The current one started with me. 3 of them started sometime in June, July. One has been with me for the past 3 years. And in June, July, I had from the building inspector a notice saying that they wanted to inspect my property. So I complied. The building inspector came and looked at it, and he made me do some upgrades in terms of electricals or little things here and there. And he passed my property. He said that he had a complaint from the neighbor, so he wanted to look at it, which he did, and he was okay. The case was closed. I didn't hear back anything from him. In October, I get another letter saying that we want to inspect your property. And I said, well, we just did an inspection, so I don't know why. So anyway, we had another inspection. Then I get a letter from the inspector saying that you're running a boarding house. So we called back. He came and looked at it again. And after he looked at the property, he sent us a letter saying you're running an Airbnb. At this point, I was really very agitated. There's enough going on in everybody's life to be, just running after these things. And I asked the mayor to talk to the mayor and the building commissioners, gentlemen, very nice people. We had a nice conversation about it. All I'm trying to make a point is I have a 5-bedroom single-family home. I'm giving it to 4 people, 4 individuals. The whole Who's not seen friends? There are 4 people living in the apartment, right? My son lives in Boston with 4 friends. Nobody can very few people can afford to pay $2,600 and $2,700 unless I give it to a family. Yeah, I could give it to a family, but in the situation where we are, at the stage of life where we are, the less I can deal with, I don't have the time. We don't have the resources to be running back and forth. This way of renting just works for me, just works for our family and our situation. And I'm not doing anything illegal. It's 4 people. Yes, they're not related by blood, but who's to say even if there are 2 people unrelated, if there's a safety issue, one is going to save the other? There are no guarantees to that. So the artifacts that I've given you is a case of a city of Worcester where 4 students were residing with leases, and it was the same situation, but the city said that this is a boarding house, and the landlords won the case because the Supreme Judiciary Court of Massachusetts said, no, it wasn't a boarding house. There are 4 people in it, and they have leases, but boarding houses are different than tenants. Boarding houses, you need to have, or lodging houses, you have to have a person there that maintains the register, that keeps track of the people, whereas a tenant is someone who independently lives there. I'm just trying to make the distinction that, and there is several, I mean, I could read it, there's several places there that they have given and said that this is not a boarding house. I've highlighted in some of them based on the fact that a lodging house is where rooms are given and you cannot cook there. It's just sleeping quarters. And a boarding house is pretty much the same, whereas a tenant is someone who has interest in the property, lives on the property, cooks, and sleeps there. So my distinction I'm trying to make here is I have tenants. Yes, I have 4 tenants. I have 4 rooms. I'm not over-occupying the place. I'm not burdening it with 10 people. I have 5 places for parking garage. These people have 3. When I had the meeting, the building commissioner was telling me that they have to go off on complaints by the neighbors, and apparently someone complained. I don't know why. I have very nice neighbors. I've gone and talked to them. They said they have no complaints. They're very nice. The people that I have are usually people who come for projects for a year and then they go back. So they're single people, and they've never created any problems. There's never been any police in my house. There's never any complaints about disturbances. So, I'm sure whoever is complaining, he's not happy with me, or he's not happy looking at the people coming in and out. I don't know. I wish I knew so I could go and address those concerns. But I just want to rent my property, just make enough to pay the mortgage and be done. I'm not asking to make a lot of money out of it. I don't want to keep running and, fighting with the building commissioners and, going back and forth. Plus, I know that whoever this neighbor is going to constantly complain about us. And I just want to set the precedent. Well, I just want to finish it here and say, I don't want to keep anything behind. Just say, yes, I am renting it to 4 people, but they are long-term people. I have not done anything illegal, and I think I should be allowed to rent my property to just at least make the minimal mortgage. That's all I have to say. And I don't know, Shakib, if you want to say anything.
No, not really. Good evening, sir. Not really. I don't have to say pretty much. She said everything. I can't really understand. We lived there for 6 years, and it's a lovely neighborhood, and I have no idea. I can think of only one person that someone requested me there. I wouldn't like to name the person, but someone requested me there to since we are not living there, they wanted to do our yard work. I happily said, he's my neighbor, and I gave him the basement key and all, and suddenly I realized all my lightings and lot of stuff, including the hinges of some antique property, they were missing. So I called upon him and I said, look, he said, no, well, I thought that I'll donate it. I said, you should have asked me. You can't do that without my permission, So I said, on a good note, I said, look, I'm done with this, and if I owe you anything, I'll pay you. And if I don't, you don't have to do any work in my yard. And after that, we started getting some kind of notes on the doors saying that, oh, this is not done. And, my tenants used to call me and tell me, and once or twice I went and I collected those notes and I read them, and handwritten notes by somebody saying that, oh, your yard is not clean. And although we kept someone else to do the work after that. So, I can only think of that person, but I'm not really sure if he's doing that.
All right.
That he's the one who's complaining.
It's unfortunate, we're all well aware of neighbors because we encounter that situation daily. Sure. And really what we're here about tonight is zoning. And the zoning issue.
Okay.
Okay. It may have been precipitated by the scenario you just gave us, what took place there, but we're here about the zoning issue. So I'm going to ask Mr. Miller to come up and just summarize why you had to come in front of us, where the violation, so to speak, is with respect to zoning, and see if any of the board members might have any questions in that regard. But just stay here, and we may ask you the folks to come up again.
All right.
But if Mr. Miller would just sit down.
Here, you want these? So we were brought to this property through a neighborhood complaint, as was stated by the petitioner. I believe when one of my building inspectors first met with the petitioners, he was told that they at one point had 5 people living there, but now had 4, and I believe that was confirmed in our meeting that we had at the mayor's office. The complaint did include a complaint about an Airbnb, a short-term rental, which was found to be untrue. However, it was confirmed by the owner twice that they were renting to 4 people who were unrelated, which goes back to what we had just previously spoken about, the city ordinance defining a family as no more than 2.
Can I stop you, Nelson?
Sure.
Just because the way you presented that, I want to just be clear. When you talked about Airbnb, you said unfounded. Are you saying that there was no determination made that these folks were out there renting it? Is that you're saying that?
That
correct?
was how it was explained to us by them.
By them. Did someone else make that accusation, though?
When the complaint came in, that was part of the complaint.
Okay.
So, like most complaints, they come in and sometimes they're real and sometimes they're not. And in this case, half of it was real and half of it was not.
Okay. The real part was that there were multiple individuals residing, and the unreal or untested or proven was that they were using one of the social mediums to advertise.
Exactly. Yeah. So the violation at hand is the 4 people unrelated. With regard to the Worcester versus College Hill Properties case, which I think you received a copy of, that's probably one of the most used and misused pieces of legal work that there is when it comes to this type of argument. It primarily is a sprinkler issue. We're not asking them to sprinkle the house, but the long and short of that is the definition of a lodging house relative to a tenancy, and tenancies tend to relate to apartment buildings where people have certain access to portions of the building and not other portions of the building. A lodging house, as defined by Mass State law, is specifically mean a house where lodgings are let to 4 or more persons, not within the 2nd degree of kindred, which is where some of our ordinance comes from. And then additionally, when you get into the the fire code, which doesn't always have the same definitions that we have. Lodging houses, buildings in which separate sleeping rooms are rented, providing sleeping accommodations for persons on either a transient or permanent basis with or without meals. So the basis of that case, and again, it really has nothing to do with the basis of our violation, which is the ordinance of no more than 2 people. But the basis of the Worcester case is the difference between owning a home and renting it out to people versus multiple people renting an apartment. So the case doesn't really apply to this situation.
Okay. And so our violation here is the more than 2 individuals that are unrelated.
More than 2 people,
which was the focus of the case.
Yeah,
we just
and
had.
as was stated by the petitioner, we did have a meeting with her and the mayor, and it was, it was a good meeting, and we had a lot of discussion about all this stuff, and her explanation was exactly what it was tonight, that they have this house and they have to rent it out to a certain number of people to afford it. Unfortunately, that's not something that I'm allowed to take into consideration when evaluating a violation.
Right. Okay. Before we let Mr. Mill leave, anyone have questions for him? No? Oh, you got him? Okay.
You're saying that you can't rent to 2 or more unrelated people? Is that or a residential home can't be occupied by 2 or more unrelated people?
Yeah, any dwelling unit, whether it be a single-family home, an apartment, within an apartment building, that family definition that we have within the city of no more than 2 people unrelated would apply.
Thank you. That's our current bylaws. Mm-hmm. Okay. Anyone else? No. All right. Thank you, Mr. Miller. And yeah, please. Sure.
So, like I said earlier, we've had a very good meeting about this, and I've brought forward a lot of my concerns with this ordinance where 2 or more unrelated people cannot live together. So we know the housing situation everywhere. We know people need housing. Malden is growing by leaps and bounds, and people need place to stay. I can give it to one person. He's not going to be able to afford it. He's going to go sublet it. A family is going to go sublet it. $2,300, $2,400. The rents are astronomical. It's hard to keep up with the housing market today. I would, before you take into consideration your decision, please take into consideration the fact that there's 4 rooms in the house. Having only 2 people live there and afford that rent is hard on everyone. It's a hard thing to expect. It's a hard thing to do. I feel like the house that I bought with a lot of hard work and everything, I should be able to maintain it by just paying the mortgage. I'm not trying to make a lot of money. I'm not running an Airbnb.
Right.
If for that I need to put 4 people in, I don't see. I just hope you take that into consideration. And I'd also urge, in fact, I was telling Mr. Miller that if we have to go to the council and say, this ordinance doesn't hold good anymore, 2 people in a house or in a bigger house like that.
I actually didn't want to interrupt you a minute ago, but that was my thought, that you should be in front of our ordinance committee.
I did say to both of them that I'll come and speak about this. Right. I work for the town of Burlington as well, so I have no problems. I can bring forth these issues because these are ridiculous issues. What was good 20 years ago is not good anymore. Right. We have to take into consideration everything that's going on in Malden. We have to take into consideration the rents. People need space to live. It's crazy. There are no houses in the market. It's how can people afford $2,300? I cannot afford it. I cannot afford it. That's why I'm trying to rent. I wish I could just pay $2,300 every month and keep my house going. I can't. So for a middle income group of person, these rents are just too much to afford. Anyone that takes that, I even think like a family who wants to live in Malden can't afford $2,300. It's way too high. It's way too high for them. We have to look at everything that's going on. I know these ordinances, and he's right. He's doing his job. The building inspectors are doing their jobs. I don't have anything against that. I'm just saying that these ordinances are so outdated. Things need to change. Things really have to be in accordance to what is going on today.
All right, thank you.
Thank you.
Motion. Anyone? Emily?
I just want to say that I really feel for you, but unfortunately we don't have the power to overturn a zoning ordinance. So in light of that, I'll motion to uphold the building commissioner's citation.
And all those in favor? Aye. Aye. So unfortunately, by a vote of 5-0, we are going to uphold Mr. Miller's violation notice. All right. Thank you, folks.